Next order.
Order number 9, the Kenya National Examinations Council Amendment Bill, National Assembly Bill number 42 of 2016. Third reading, question to be put.
I put the question. Then, yeah. There being no contrary view, I proceed to put the question as I confirm that the House quorates, which is that the Kenya National Examinations Council Amendment Bill, National Assembly Bill number 42 of 2016, be now read a third time. Will as many as of that opinion say aye? Aye. As many as of contrary opinion say nay? The ayes have it.
A bill for an act of parliament to amend the Kenya National Examination Council Act.
Before we proceed to the next order, allow me to recognize the presence in the Speaker's Gallery and in the public gallery of students from the following institutions: Limuru Girls High School, Limuru Constituency, Kiambu County; State House pupils from various counties: Katangi Secondary School, Yata Constituency, Machakos County; St. Mary's Primary School, Westlands Constituency, Nairobi County; Lake Naivasha Girls High School, Naivasha Constituency, Nakuru County; Bridge International Academy from Westlands Constituency, Nairobi County; Nyaga Secondary School, Githunguri Constituency, Kiambu County. They are all welcome to observe proceedings in the National Assembly this afternoon. Next order.
Order number 10, the Building Surveyors Amendment Bill, National Assembly Bill number 25 of 2017. First reading. A bill for an act of parliament to provide for the registration of building surveyors and for connected purposes.
Next order.
Order number 11, the Election Offences Amendment Bill, National Assembly Bill number 26 of 2017, first reading. A bill for an act of parliament to amend the Election Offences Act 2016.
Next order.
Order number 12, the Companies Amendment Bill, National Assembly Bill number 23 of 2017, second reading.
Debate had already commenced. How far is gone? Oh yes, Leader Majority, you are interrupted by the Honorable Odanga, who claimed that there was no quorum in the House. Yes, Honorable Manzo, what is your point of order?
I rise to seek guidance from you, Mr. Speaker, in relation to the matter of Yala. After the last time we convened in the House and we passed the motion, Mr. Speaker, there is no update as to what we do next, and the matter is very urgent for the purposes of the country.
You know, it's only fair that the member for Makueni has always reminded Kenyans that he, as a trained lawyer, just look at the Yala regulations. Immediately after Regulation 6, the processes that follow thereafter. But because you sought information, I can tell you that there was a notice which was put, given to the leader of majority, leader of minority and leader of in the National Assembly and leader of minority in the Senate, and they were supposed to comply with the communication contained in that, in the letters from the two clerks, and they were supposed to submit, the CONT coalition was supposed to submit the additional names by the fall of the day today, by close of business today. For that reason that the clerk of the Senate and the senior deputy clerk of the National Assembly are holed up at the county hall waiting for those names. We can only proceed after close of business today. Perhaps in house business we will be given more information. Thereafter, then the other processes provided for will take place. So nothing is lost. That is the latest information. So as of now, that bid is being handled by the two clerks. Yes, Honorable Duale.
We both houses have adopted the report of the committee. But Mr. Speaker, there was regulations and timelines which were gazetted by the two presiding officers, which had serious timelines on when to do the nomination, when to do the elections, when the committee was to do the vetting. So, Mr. Speaker, I remember the last day for the election was the 25th of May 2017. And the nomination has passed. I am wondering what the two presiding officers are doing accountable, Mr. Speaker, is an illegal activity. Because until and unless a new gazettement is done with the new regulations, I don't see what the two presiding officers are receiving. They can't receive nomination from different people now. So we need guidance. Second, as per that gazetted regulations, 2nd of June was the last day when you and your colleague, the Speaker of the Senate, were supposed to submit the names to IALA. That didn't happen. And second, today is the 6th of June. So, Mr. Speaker, I need your guidance. Our two presiding officers, if at all they are at county hall receiving nominations, then they are doing what is called electoral fraud and illegality. That's an electoral fraud. Because there were Kenyans who presented nomination papers. If there are other Kenyans who their papers are coming now, then I'm sure there should be a gazettement from the Speaker. I need that guidance because 2nd of June, as per that regulation, which is gazetted, which I have, was the last day. Now is 6th of June. If parties want to comply with the report of the committee, I have no problem. But I think the two presiding officers need to consult the House and do a new timetable for this process to take place. They can't just do kangaroo, nomination somewhere. I mean, this is a country where we want to do things in the right way.
Well, the report of the Honorable Pio, you see every opportunity as an opportunity for debate. You have something you want to say in addition?
Mr. Speaker, thank you very much. I don't wish to debate at all. But I've got one comment to make. Even though this House, just like the Senate, did pass that report of the Joint Committee, the report whose import, in my view, in my very respectful view, is to amend through the back door the statute, the treaty, and the regulations, the rules of the East African Assembly. Mr. Speaker, as a coalition, I'm aware that we don't intend to add any single name on top of the 4 or 5 that we had submitted. So I want to agree with him for the first time that they are sitting there is in vain, those two officers.
You are agreeing with him for the first time?
That the sitting of those two officers in County Hall is in vain, because the coalition of NASA or CORD will not add a single name to the ones we had submitted. So we need to actually agree on the best way forward on this matter, because we cannot amend the regulations of the East African Legislative Assembly or the treaty itself through the back door. If the intention was to amend the regulations or the treaty, there's a process through which it can be done, not through a report of a joint select committee of some few people. Mr. Speaker, thank you very much.
Honestly, honourable members, I don't know whether have we forgotten what the report recommended. Yeah, because already you as a house passed that report, and if you can trace back your memory, the amendment which was withdrawn, which was proposed to be moved by Honorable Mwandegu, and the effect of deleting 3 or 4 of the recommendations. Just look at those recommendations and then, so that you also debate from a position of knowledge. Because here, it's not my business to debate. It is your business to debate those recommendations. As it is now, the proposed amendment was withdrawn, and that's the information I have, and therefore the report was passed without amendment, just like it had been passed in the Senate. If, on the other hand, anything that comes from the administrative processes that the presiding officers are undertaking is in the opinion of both myself and the Speaker of Senate unconstitutional or irregular, allow us to apply ourselves to those recommendations in the face of the regulations, not the treaty, the regulations dealing with elections of members to the IALA. So if anything is unprocedural coming through the administrative exercise that is being done by the 2 presiding officers, then obviously we will communicate that to the House, and the House will be at liberty to take whatever decision it proposes to take thereafter. But before they have come to us, and remember, though you adopted that report on Wednesday afternoon, you adopted the report on Wednesday afternoon. The next day was Thursday, 1st of June, which was not a sitting day. The presiding officers had to do whatever they thought was necessary administratively, but then they will report. Because it is not the presiding officers who will actually see the report first. It is the joint committee, which will first receive their report. Then the joint committee will bring whatever report they have, and we will make of it what you choose. There's no matter of core principles in this one. You know, this language is becoming very fashionable. The member for Endebess is suggesting that there could be some principles. There isn't any. So let's just wait for the 2 clerks to finish the administrative exercise that they are doing, and they will report to the joint committee, which I am informed is scheduled to meet on Friday this week. It's after that they have met and deliberated on what it is that they will have received from the presiding officers, that then we can take a decision, either to deal with the matter one way or other. But if you recall, in that report, there was a deadline of 4th of June, which was indicated there. And therefore, what the leader majority is saying about the deadlines is true. They will need to, the joint committee will need to address that issue. But I cannot do it now because it will be taking any action at this point would be inchoate, it will be premature. I think the best thing is just wait for the joint committee to bring us a report, and I'm sure the House will be able to express itself. I can see the member for Ugunja is quite happy about having to deal with the matter as he best understands how. So let's proceed. Whatever comes out, I'm sure you are up to the task. You'll be able to sort it out. I cannot express myself on the number of names to be brought because it It is not within my purview. I do not have the power to bring any name. Let's move to the next order which we are on. The leader majority, you are interrupted while moving business of appearing as number 12 today.
Yes, Mr. Speaker. Speaker, I beg to move that the Companies Amendment Bill 2017 be read a second time. Speaker, the Companies Amendment Bill 2017 seeks to amend the Companies Act 2015 in order to improve the operationalization of that act. Speaker, Kenya is part of the global market. And in order to attract investment, it is imperative that the laws relating to companies be in line with the global trends and best practices. The Companies Amendment Bill 2017 is not only meant to improve the provisions of the extent of directors' liabilities, the extent of directors' disclosure, and the extent of having remedies for shareholders in case of a dispute to further protect investors. But also, these amendments will try to see whether they can ensure the ease of doing business in our country is fast-tracked, whether we can use this law to protect minority investors, and above all, Mr. Speaker, these amendments want to clear the ambiguities and the errors that are found in the law that we passed in 2015, which was one of the landmark pieces of legislation that the 11th Parliament can be proud of, Mr. Speaker. Mr. Speaker, I'll just go on the highlights of these amendments. Members can remember that bill was a bit very, very heavy, that act that we passed. If you pick like clause 7 of the bill, it is proposing to amend that act by completely repealing and replacing section 90 of the Principal Act. And what does it do? It does to provide for the requirements for conversion or how you convert a public company into unlimited company. So that clause 7 is just dealing with the conversion. Clause 8 of the bill, Mr. Speaker, proposes to amend section 93 of the Principal Act. It's at the back of the bill. And what is it trying to achieve? The amendment to section 93, Mr. Speaker, of the Act wants to expand the application in terms of the ownership of a company. And they want to expand the application to include information relating to the beneficial owners of the company. And this clause also tries to propose to amend section 9 by excluding public quoted companies from lodging a copy of any amendment made within a period of 14 days after any changes are made to the registrar, because the registrar or the register can change daily. So it's giving a time frame for companies which are quoted or which are public quoted companies. They cannot lodge any amendment, a copy of any amendment, unless it's done within 14 days. Mr. Speaker, clause 10 of the bill proposes to amend section 123 of the Principal Act and this is to expand the definitions or the definition of the members of the director's family, to include a brother, a sister of the director, a brother or a sister of the spouse of the director, a grandchild of the director, a spouse. And the Speaker, all this is done within the reading of transparency and accountability in the management of both public and private companies in our country. And the Speaker, this is as a result of what happens when big companies, big banks like Chase Bank, Imperial Bank, when they collapse, the biggest reason why those companies or those banks collapse is because the relatives and the family members of those banks didn't make full disclosure to the registrar of companies on their shareholding or what they own in that company. So there's a lot of inside trading or insider trading that goes on both in the private and in the public companies. So Clause 10 is trying to cure that. Clause 11, Mr. Speaker, proposes to amend Section 135, subsection 1 of the... Before, Mr. Speaker, people could hide the various boards where they sit, either private or public, and I think this will also help the taxman to collect the necessary revenue by being in those positions. Clause 12, Mr. Speaker, proposes to amend Section 146 of the Act, and this is to expand the situations, the instances where a director is to avoid a conflict of interest when dealing with the matters of a company, and to give clear mandate on who can give authorization. Mr. Speaker, if you are a director of a company, for example, you must declare your interests. You cannot do business with that company. All this is to make sure that we create very good corporate governance structure for the running of both the public and the private companies in our country. And within the reading of Clause 12, the amendment, that clause further provides for penalties if one contravenes that section in terms of not declaring the conflict of interest. Clause 13 proposes to amend Section 147 of the Act. And again, this is to prevent a director from accepting a benefit from a third party if the duty imposed does not give rise to a conflict of interest. So by mere fact that you are a director of a company, you cannot receive a bribe, a benefit from a third party, and that amounts to conflict of interest. Clause 14, Mr. Speaker, proposes to amend Section 151 of the Act, and this is to ensure that any person who is a director of any company must declare his interests and to factor in 10% of the value of the assets of that company. One, you declare your interest. Secondly, you must factor in 10% of the value of the assets of that company. Clause 16, Mr. Speaker, proposes to amend Section 162 of the Act. And this amendment deletes subsection 6 and 7 of that 162, which gives the directors an excuse to avoid liability, except if they show that they were unaware that the transactions were invalid. Mr. Speaker, this is a very serious matter. That section which is being deleted, 6 and 7, was the one that many directors were using the law to avoid liability for a crime they have committed. For example, a bank goes down and the bank directors blame the central bank. They go down with all the resources of the depositors. So that section is deleted so that no director of any company can have an excuse or can escape a liability for whatever that will happen to the shareholders. Clause 19, Mr. Speaker, proposes to amend Section 246, subsection 1 of the Act. And this is just to define what a company secretary is. Clause 21 of the bill, Mr. Speaker, proposes to amend Section 308 of the Principal Act by inserting a new subsection that requires every director or directors to organize their annual general meetings, which permit the holders of any class of shares to vote as a group on any variations on the rights of the class to give the holders of that class share right. For example, there are many different shareholders in a company called Kenya Airways. So this amendment is saying, regardless of the shareholding of the various shareholders, the percentage they hold, they have a right to be consulted when a serious matter is being made. When they are holding their annual general meeting. Mr. Speaker, Clause 25 of the bill proposes to amend Section 392, subsection 2 of the Act, and this is to provide that the variation of the rights attached to any class of shares held by an investor in a company having share capital can only be effected, can only be implemented if the holders of the shares of that class consent to the variation which is being done. So a board of directors cannot do a variation in terms of the shareholding without prior consultation with the shareholders themselves. So, Mr. Speaker, all these amendments is just to align the new act that we passed in 2015 into a very good corporate governance system, and that will make ultimately the ease of doing business in our country more efficiently. Mr. Speaker, if I move faster, Clause 39 of the bill proposes to amend Section 626 of the Act, and this is to refer to companies within the East African community, and to include a company and its subsidiaries that carries on cooperative society activities, microfinance activities, trade in insurance, markets, banking, in relation to companies excluded from the small companies regime. I think this amendment just want to make sure that they open the field for the medium and small time companies to do business and to have subsidiaries within the framework of the East Africa community. Mr. Speaker, Clause 52, 53, 54, and 55 of the bill proposes to amend Section 974, 975, subsection 4, 975, subsection 5, 978, and ultimately the 6th schedule of the Act, respectively, by just deleting the words certificate of registration wherever they appear in those sections. So it's more of a cleanup. Mr. Speaker, clause 42 of the bill proposes to amend section 705 of the Act to provide that a company annual returns shall be signed by either the director or the secretary of the company to ensure transparency. So basically, this is a bill, a very important amendment. The Companies Act we passed in 2015 was a very landmark piece of legislation, and I'm sure those who wear the shoe, the House does the legislative making policy. But those who use these laws, who implement, who foresee, and they go through the operationalization of the Act, have realized that they need 1 or 2 or 3 or 4 things to amend so that the suit and the shoes can fit well. With those many, many remarks, I ask Honorable Dr. Pukose, one of the very few surgeons in this House, Mr. Speaker, to second.
Honorable Pukose.
Thank you, Mr. Speaker. I wanted to let the majority leader that this is the only surgeon in the House, in Parliament, in Kenyan Parliament, both the Senate and the National Assembly. The other one are neonatologists and others. Dr. Nyikali is a neonatologist, so, and smiling across. Honorable Speaker, I want to second this very important amendment bill on the Companies Amendment Bill 2017. Mr. Speaker, this bill comes in to amend the Companies Bill that this House passed in 2015, and that was a landmark bill. It was a huge document. Many of us had a lot of difficulties in reading and understanding the very huge document that was in this House, Mr. Speaker. And I think, to me, this is very timely for the majority leader to bring this government bill to the House to be able to make amendments and repeal some of the sections in the 2015 Companies Act. Mr. Speaker, this creates an enabling environment for our investors, for business people, for even our own Kenyans who want to invest, form companies. And Mr. Speaker, when you look at it, where you are even director of a company, where it gives you now that you must take responsibility in running that company. You must also take liabilities in running the company. I think it's a wake-up call, Mr. Speaker, because this country, we've had cases where companies have been formed over a period of time. Look at the insurance sector. There are many insurance companies, right from the Kenya National Assurance, which came up and people ran them down. They collapsed. Other insurance came, they collapsed. You had also HMOs, which came up. People invested in them. They got away with people's money in the health sector. We have had banks where even small investors go and invest in banks. And at the end of the day, the banks collapse. They collapse with the money of even the mama mboga. So, Mr. Speaker, this is a very important cleanup that this House is coming. And I think this is in line with what the President recently said, that with ramifications. It is cleaning up the Companies Bill. And just look at the period. It's now 2 years since we passed the Companies Act. Now we are coming in. It means it's a very dynamic law. It is where people are looking at it and saying, this is the kind of improvement that we need to do. And I think it is the same breath that we should also be able to look at our Constitution, which has been rated as one of the most progressive constitutions in this country. Let's look at it as we even go into the elections. After and beyond the elections, are there areas that we feel needs to be improved? So that at the end of the day, we have a country that all of us, whether you are in government or whether in the opposition, we love it, and we have laws that will govern and create an enabling environment for everybody, whether you want to invest, whether you want to engage in employment, whether you want to set up companies, and all in that Mr. Speaker, I support and I second this bill. Thank you.
Honourable members, I propose a question, which is that the Companies Amendment Bill, National Assembly Bill number 23 of 2017, be now read a second time. Honourable members, earlier on I indicated that I had some message to deliver. This message is on nomination of a person for appointment as Director General of the Financial Reporting Center. Honourable members, pursuant to the provisions of Section 25, subsection 2 of the Proceedings of Crime and Anti-Money Laundering Act of 2009, as amended by Section 5 of the Proceedings of Crime and Anti-Money Laundering Amendment Act 2017 and Section 5, subsection 1 of the Public Appointments Parliamentary Approval Act 2011, I wish to convey to the House that I have received a request from the Cabinet Secretary for National Treasury asking the House to approve the appointment of Mr. Saitoti Kimerei Maika as the Director General of the Financial Reporting Center. Honourable members, the Principal Act requires the Anti-Money Laundering Advisory Board to forward to the Cabinet Secretary for National Treasury a name of a selected candidate recruited competitively for appointment. Thereafter, the Cabinet Secretary is required to forward the name of the candidate to the National Assembly for approval. Further, Section 25, subsection 2 of the Proceedings of Crime and Anti-Money Laundering Act 2009 requires the nominee for appointment as Director General to be vetted and approved by the National Assembly before appointment into office. In forwarding the name, the Cabinet Secretary has also forwarded the following documentation. 1. The advertisement for the position of Director General Financial Reporting Center. 2. A write-up on the recruitment process. 3. Interview results for the position of Director General. And 4. The curriculum vitae of Mr. Saitoti Kimerei Maika. Honourable members, in this regard, I hereby refer the name of the nominee, Mr. Saitoti Kimerei Maika, including the above-mentioned documentation, to the Departmental Committee on Finance, Planning and Trade to undertake the necessary approval hearings. Thereafter, the House shall consider the nominee in accordance with the provisions of the Public Appointments Parliamentary Approval Act 2011. Honourable members, Section 8, subsection 1 of the Public Appointments Parliamentary Approval Act 2011 requires the National Assembly to either approve or reject the nominee within 14 days from the date on which the notification of nomination was given. However, given that the House is expected to proceed for sine die adjournment on Thursday, June 15, 2017, I wish to guide the committee and the House as follows. 1, that the committee should notify the nominee and the general public of the time and place for holding the approval hearings in good time. The notification should therefore be made immediately. And 2, that the committee may thereafter commence the necessary approval hearings and submit its report to this House on or before Wednesday, June 14, 2017, during the morning sitting. I thank you, honourable members. Honourable Nyikal.
Thank you, Mr. Speaker, for giving me the opportunity to contribute to this motion. Mr. Speaker, I arise to support the bill. Mr. Speaker, the company's bill, as others have said, was a huge document that one literally needed a basket to carry to bring to the House. It was an extremely important document, Mr. Speaker, and we went through it, and therefore these amendments, I think, are refining what was an extremely important document and bill. The whole purpose of this, Mr. Speaker, and why I support it, is actually to make business environment in the country easier and to make business in Kenya competitive so that we can attract investors both locally and from foreign destinations. Mr. Speaker, business is the essence of all nations. All the revenues, all the resources that countries own arise from businesses, and therefore, Mr. Speaker, it is important that the environment of business is made as supportive as possible, and this is what this bill does. Mr. Speaker, it addresses areas that have been of concern in this country as far as business is concerned. For example, Mr. Speaker, it has been known that starting business in this country can sometimes be long and can sometimes be very difficult. We are aware that companies have tried to start businesses here and have actually had to move away because they couldn't do it as quickly as possible with a lot of impediments put on their way. These amendments are really making those much easier. Mr. Speaker, this bill also makes it much clearer on the responsibilities of directors for that to now be done. And in fact, it is now in law what their liabilities are. I do realize that it also tends to protect them, but Mr. Speaker, the pretense that the directors didn't know the consequences of their actions in advance can no longer be accepted as a reason for not taking liability. And Clause 16 of this bill actually addresses that. It would be really a travesty of justice if directors would say, we undertook this transaction not knowing what these consequences would be, and then people suffer. It would actually go against the known doctrine that ignorance is not really a defense. Mr. Speaker, that is something that is very important to business people. Mr. Speaker, shareholders are the mainstay of many big companies and is the main way that people do benefit from companies. And therefore, this bill brings clearly how the disputes that arise from these shareholdings can be resolved. Otherwise, people will not invest, and therefore companies will not grow. And even if they do, those who invest will not get their rightful shares in the proceeds of these companies. So those remedies are needed, and this bill addresses that. Mr. Speaker, it is important to protect the shareholders, and particularly the small shareholders. And again, this is done in this bill, because when companies fall, it is often the small shareholders that actually lose out. Mr. Speaker, similarly, the minority shareholders suffer in the same way, and again, they are protected in this bill. So, Mr. Speaker, if you look at this bill, there are clauses that are really important, and we can't go through all of them. As we said, if you look at Clause 11, Mr. Speaker, it requires a director to close any other company directorships that the director holds. Mr. Speaker, this has been a big loophole in this country, where people actually trade with themselves, whether they're in companies that are owned by the public, whether they're companies that are state-owned, then they form companies on the side, and when they're actually transacting businesses, they actually transact with themselves. So, Speaker, you'll remember when there was time in this country, we decided that some state assets should be disposed of. What people did is people actually, the same directors in the parastatals formed companies and actually acquired those assets at throwaway prices. Clause 11 in this case would have protected the country in that area. It also clearly in Clause 12, Mr. Speaker, indicates that there has to be a clear declaration and to avoid conflict of interest when dealing with matters of the company. Mr. Speaker, that is something that again has been a major problem. The principle of conflict of interest has been abused and ignored to the extent that these days, in some places, it looks like there is no such thing as conflict of interest. To bring it clearly in law is something that is really necessary. Mr. Speaker, if you look at the class of shareholders prior to this bill this law coming in place and now being amended by this bill, the directors had the power to actually vary the holdings and the values of the shares of class of shareholders without the approval. This, Mr. Speaker, in clause 25 is now dealt with, and their approval has to be sought. Mr. Speaker, as you know that right now in the country, in the life of the parliament at this time, the focus has to a large extent moved to the area of survival of the members of this House. So we may not have read into a lot of details, but in general, Mr. Speaker, this is a good bill. The clauses that I've mentioned are extremely important, and with that, Mr. Speaker, I do support this company's bill.
Honorable Wara.
Thank you, Mr. Speaker. Mr. Speaker, I rise to second the various amendments to this bill. Indeed, this bill is very timely in relation to the various concerns that have been raised that would make the issue of holding companies more accountable. When I look at some of the proposals that, of course, are very important, is, for example, the definition of who is an associate to that company, so that then, of course, you look at the issues of the spouse and the children, or an associated body corporate, and such legal entities. And this is important because in a situation where sometimes you would want to go and look at the particulars of a company so that then you know, for example, if there have been proceeds of crime, if, for example, there have been some malfeasance, then sometimes you lose the details because then this company is owned by this other company, and sometimes you cannot quite, get to the bottom of it. And so, Mr. Speaker, these amendments will, of course, ensure that we have a more clean, a more elaborate, way of following through issues. The other thing that also stands out is the fact that these amendments recognize the new role of electronic data in terms of companies, in terms of electronic address, and copies and forms. And I think this is very important because a lot of transactions are now being done online. And so it helps in terms of the tracking of such data, including funds, and of course, issues of eligibility and transfer, so that then they are also not, found to be, operating in an opaque environment. Mr. Speaker, I have also noted another amendment that is also critical to the transparency of the running of companies in the fact that members of a company have to be listed. They have to be listed, including the shareholding that they may have. And this is important because sometimes, the traditional way of looking at how companies are registered, you find that there are only particular some few directors, yet, you find that there are some third-party engagements that are entered into by individuals who therefore suffer as a result of the actions of some few individuals who ab initio have been recorded as the true directors of the company. So I think this is going to be okay, especially when you look at issues to do with issues such as land transaction and such properties thereof, so that then even when it comes to issues that may go before the court of law, then you have full disclosures, and that if such, registers are not well updated, then there could be some form of recourse or deregistration. So I think it is important also to note that the issues of holding companies have been addressed in these amendments, particularly as I had alluded earlier, is how then do you deal with issues of subsidiaries? How do you deal with issues of companies being owned by other companies? And I think that has been a very important aspect. It will help in terms of even issues of jurisdiction, issues of determination of any dispute, and whatever area that has actually been covered, if such issues arise. And this is also very important because I am on record as having brought a motion on the floor of this House about youth and innovation. And one of the great challenges where we have had our youth being taken advantage of is where you have the issues of intellectual property rights. And so that definition has to include trademarks, registered designs, and copyrights will really help in terms of how is it that we can administer such issues within the ambit of a registered company. Mr. Speaker, I think it would be important also to highlight that the simplification of the process of ownership of a company, where a single individual may own a company, is very much timely. This is because within the preferential procurement system of 30% for marginalized groups, youth, women, and persons with disabilities, then it helps entrepreneurs within our population to get an opportunity to carry out business without being bogged down by having to create directors who are dormant. And I want to imagine that, Mr. Speaker, that with that provision that is properly enhanced by the various amendments that I have seen, that we will have a situation where we spur the productivity, indeed the growth of our economy. And that this by itself would lead to a greater increase in terms of the job opportunities for young people. And taking advantage, for example, of the great development record that the Jubilee administration has had, I think it is important to ensure that the regime by the companies so encourages such an endeavor, because we have our young people who are made of fine clay, who have what it takes to actually spur the economy and to bring our development forward, just like has been the case of the standard gauge railway in relation of ensuring that we industrialize our economy. And I think with such support, combined with a very great effort of the government through the National Research Fund and such initiatives, with a greater speed where you can transport goods and services, with the idea that we have a greater road network with improved healthcare, I think it would mean that then such companies that would want to establish themselves within our country would be able to ensure that we increase that productivity, that we give an opportunity to our people to enterprise and to grow wealth, which of course will lead to a greater prosperity of our country. Mr. Speaker, as I conclude, I want to say that this is a very timely bill. It is important that it has come only 2 years after we passed a very humongous piece of legislation, and we believe that as legislators of the 11th Parliament, we have done our best to ensure that we create an enabling environment for business. Mr. Speaker, I support.
Michael Onyura.
Thank you, Mr. Speaker. I also rise to support this bill. And I want to thank those who went through the big...
Member for Igembe Central Imenti, sorry.
Thank you, Mr. Speaker. I think it is important for school children who are visiting Parliament to be advised by their teachers that when they are about to end their term in school, they should not be absent. Because they are looking at Parliament and asking, why are there no parliamentarians? And we are about to end the 11th Parliament. It is important for teachers to put students on notice. Thank you, Mr. Speaker.
Proceed, Honorable Onyula.
Mr. Speaker, that's interesting. Members are never absent. They are doing other useful activities for this nation. So, Mr. Speaker, I was saying that I support this bill, and I was thanking those who have taken their time to go through the principal bill, which, as many of us saw here when it came, it was really volumes, pages and pages. And I'm not surprised that maybe as part of cleaning up, we have quite a number of pages that are amending the same. But it's, I think it's a good thing, it's timely, because looking at it, I've noted that it's mainly cleaning up areas that had typos. There are places where there are repetitions. There were other places with overlaps. And, Mr. Speaker, even more important, issues of definitions. And we know that ambiguities can bring a lot of problems and misunderstanding. I've been following the arguments about IALA. I think some of the problems are basically related to interpretation. And so I think it's important that whenever such are seen, the earliest time is taken to clarify and even minimize those ambiguities. So, Mr. Speaker, I think this is a bill that is very important to the economic activities and commerce, trade in this in our country. Again, Mr. Speaker, I think so in the preamble or in the explanatory notes that there's an endeavor to ensure that the bill conforms to all the laws, to the Constitution, to global trends and best practices. And of course, as I've said, removal of ambiguities. Mr. Speaker, I've also noted that there is, the bill seeks to improve certain provisions regarding directors' liabilities, for example, disclosures that require to be made by the various parties, remedies to shareholders, Mr. Speaker, and of course the net effect, and that is what is important, is that it does ease doing business in this country, creates a better environment, and Mr. Speaker, with all this cleaning, it ends up being a much better and much more user-friendly document than what it was, Mr. Speaker. Mr. Speaker, there is also, I noted a provision that now, a clause that now provides and makes it easier for conversion of companies, for example, converting from public to private and vice versa, limited to unlimited and vice versa. I think all this is going to make it much easier for those who are running companies. In terms of definitions, I think they are being made clearer. The definition for company secretary has been improved. Definition for limited companies, limited by guarantee, is improved. And also, Mr. Speaker, I can see emphasis in this bill with regard to improvement of transparency through the disclosures, accountability. I note also there is a requirement on the way records should be kept, Mr. Speaker, the manner that they should be kept, including even the length, because and policies, Mr. Speaker. Mr. Speaker, looking through, I think, and I do hope that it will also help in minimizing the kind of mischief that is at times committed through companies where maybe not so trusted or people with con tendencies set up a company quickly to perform some perhaps even an illegal activity and quickly either dissolve it or maybe discard it. I do hope that this will be checked, will be taken care of. We've had very many cases at times, companies involved in an activity, at times a shady deal or questionable deals, and when maybe even the press is trying to find out those who are behind such companies, Mr. Speaker, we hear that files cannot be found, files are lost. I do hope that in these amendments and this cleaning up, these kind of anomalies will be properly checked. I think, Mr. Speaker, it's encouraging to see that the issue of conflict of interest, be it from family members, both close family members and extended families, is being addressed, just to minimize that conflict of interest, and also to ensure transparency and objectivity, and of course to protect the shareholders. Mr. Speaker, the fact that there's also been provision of penalties for cases, any breach of fairly strong penalties for any breach of the provisions of this Act, I think that's also a good thing that makes me feel quite happy to support the bill, Mr. Speaker. This provision for ways of communicating with the members of the company, that also for purposes of improving it. Mr. Speaker, again, the important thing here, as we continue to empower our people, particularly those disadvantaged, like the youth, like the women, like persons with these disabilities, that it should be made easier for such groups to be able to set up companies and be able to use them to compete maybe for tenders or related business activities as part of our empowering them, Mr. Speaker. Otherwise, Mr. Speaker, I do strongly support this company's amendment bill. Thank you for the opportunity, Mr. Speaker.
Member Vochiranganyi.
Thank you, Mr. Speaker, for giving me a chance to support this bill. Mr. Speaker, I think what this bill does shows what this country needs to do. Mr. Speaker, I think I agree with the members that when the Companies Act came in 2015, it was a very, very big document that most people even didn't go through. And I think what we see here is impossibility in implementing what we pass in this House gives us a second option to amend so that they can be implemented to the fullest. And I think what is happening here, Mr. Speaker, is a good show that not any paper that we have in this country can be implemented, and it needs time to be amended. And also, Mr. Speaker, I think I like what is being amended, like when I look at clause 11. I think when they brought these bill amendments, they have also learned from the mistakes we have done as a country. This gives the registrar to know how many companies each person owns. Otherwise, we'll end up giving the same job, different jobs into the same person. and we are not dispersing the resources we have as a country. Mr. Speaker, I think one thing that have been of concern of mine is the protection that we have of our local companies from the infringement or the empowerment of foreign companies. Mr. Speaker, I was looking here if there's anywhere that looks at foreign companies. I remember, Mr. Speaker, when I came in, during that, I brought an amendment for the shareholders of a foreign company before they work in this country, Mr. Speaker. And I don't know how much that has been implemented, Mr. Speaker, so that we protect our young men. No matter how much we try to do this, Mr. Speaker, but we have foreign companies coming and taking the jobs from the local companies, then we will be doing no job and no favor to our young men, Mr. Speaker. Another issue also, Mr. Speaker, that we have noticed is we, as a House, we passed the 30% rule, whereby for every tenders that is given, 30% should be given to women, people with disability, and youth. Mr. Speaker, I think as a leader, I've noticed one thing, that these people that apply for these 30%, some of them, Mr. Speaker, are not youth. We find that people have used their kids, their young people. It's the same person, but they use the identification of their kids or their wife to open different companies, and then they will apply. So you'll find that if there's a carer job being given, Mr. Speaker, you'll find that a job is given to a company thinking that it qualifies as youth or women, but is the same person that has been applying with the other companies who is a big person. So these shareholders or the people that owns this company, Mr. Speaker, are coming up with tricks to be able to trick the system so that they can benefit and keep benefiting. And the people that we intended when we passed that bill, the people that were intended to benefit are not benefiting because these youths are not given the chance. The real youths who have come together to form companies to apply for these jobs are not getting, because those big people that have always gotten this job, they have known the procurement tricks, are the ones still getting the jobs using different tactics and are taking from the young people. Mr. Speaker, I think if we can find ways of preventing those things, Mr. Speaker, I think that will help our country grow bigger, Mr. Speaker. I think also, Mr. Speaker, one thing I like here is whereby your family, I like that, because now that will be able to avoid the issue that I just mentioned, that every director should also include their next of kin, Mr. Speaker. If you have a child, if you have, if you should include your wife's name, you should include your children's names, all your family members should be included in the shareholders, so that people cannot go and open other companies using their children. So that people cannot go open other companies using their wives, so that they can get what is meant for the people of the youths and the other people. Mr. Speaker, also I like the idea of transparency. This improves the transparency that people cannot benefit from the third party if they're shareholders. So I think, Mr. Speaker, this is a good thing. And I think as a House we should pass it so that it can give power and it can amend the bill that we had. And this, Mr. Speaker, shows that as a country, I think there have been a lot of problems that we have been facing with our Constitution. And I think this, because of the big and the huge Company Act that we passed in 2015, that the government and the implementers of that act have discovered that they cannot implement everything. And now they have brought it back to us to help them amend so that it can be implementable. It's about time, Mr. Speaker, that we as leaders and we as a country should start thinking about how to bring amendments and to change our Constitution. Because we have...
And I think it's going to give rise to fair competition. Honorable Speaker, Clause 12 2D, in my view, is a good provision in terms of it seeks to define what a personal interest of a director is. Honorable Speaker, it is difficult to define the word personal interest, because whatever is personal can fairly be very convoluted. But I really think that in trying to narrow down what personal interest is with regard to being a party to the transaction, or as material financial interest, or as material financial interest in the transaction, I really think that distilling what personal interest in that manner is, Honorable Speaker, I really think makes the Company Act fairly very tidy, and I think it's very useful. But Honorable Speaker, if you look at clause 23, in my view, though very good, clause 23(1), Honorable Speaker, if you want to read 23(1) says, the directors of a company may exercise a power of the company to grant rights to subscribe for or to convert any security into shares in the company, only if they're authorized to do so by the company's actors of interest or by a resolution of the company. I really think that, in my view, I would really propose a further amendment to that particular clause, Honorable Speaker, because one, there are moments when articles of interest of companies are always tweaked or tinkered with by various directors. And if at all you let the articles the company's articles be the ones that dictate whether the directors can allot shares, I think that would be a fairly tricky scenario. I really think that we only give the directors power to deal or allot shares of the company only by resolution of the company, as opposed to letting that be a content of the company's articles of association. Honorable Speaker, clause 28 is a very interesting one, because clause 28 talks about issues of good faith. And it says that the company's principal purpose in terms of giving out money for its holding company would only be giving out money where there is assistant is in good faith or in the interest of the company. Honorable Speaker, the issues of good interest issues of good faith, Honorable Speaker, are very relative. And it's sometimes very difficult to distinguish what is good faith and what is not good faith. I really think that if at all you want to restrict the space and the sphere of holding companies in terms of giving money, I really think that particular thing need to be properly defined. I really think we need to discover and disclose what powers the holding companies ought to have, and each time that holding companies are going to be giving out money, I really think that needs to be properly and clearly defined. Honorable Speaker, clause 33 of this bill, I think is averagely very important. It just shows how important the use of English words sometimes can be, because clause 33, Honorable Speaker, requests or directs that we do change the word may that is in section 511 of this particular act. Honorable Speaker, that particular change of substituting the word may with the word shall radically actually changes what was otherwise an oversight in terms of making this legislation, Honorable Speaker. Because a private company that is limited by shares or a company limited by a guarantee shall not offer public securities of the company. Because then, Honorable Speaker, if at all we let the word may stay as it was then really opening companies limited by guarantee or company limited by shares to be then public companies, which then again was then beating the purpose why we classified companies in that particular manner. So I really think that was a really interesting amendment there, and I really think it's a fairly important amendment in clause 33. Honorable Speaker, I have a particular interest in clause 37, which chooses to define the word spouse as husband or wife. I also thought that they should have stretched the meaning of the word spouse to mean partner, given the sort and nature of relationships that we have in the world moving forward, so that at least you do not want to restrict the word spouse to only mean husband or wife, but the word partner, I think, Honorable Speaker, in my view, would be I don't know what is exciting Honorable Dwale in the word partner, but Honorable Speaker, I really think that a domestic partner in that particular, I'll be proposing that particular amendment, and I'm hoping that the Honorable Majority Leader can agree with me on that particular one. But Honorable Speaker, I am looking at clause 51 of the Act, and I'm wondering why you would want to delete clause 51 of the Act, but I'm happy to be schooled, because if at all you delete clause 51 of the Act, if you want to delete that particular provision, maybe we need to provide for a transitional clause for companies that were hitherto registered under a different regime, as opposed to just deleting it in total. Honorable Speaker, I think my time is up. I'd like to thank the Majority Leader for scrolling through the big book, which scares many members of Parliament, and trying to find very useful amendments to make. I do support, and thank you, Honorable Speaker.
Member for Kibra.
Thank you, Mr. Speaker. As Honorable Agostino said, the Companies Act was really indeed a big book, and as was noted by the member for Chirangani, and it demands that legislators really work hard on following through on the work ahead in front of us, and maybe engage strongly with the support staff from Parliament, as well as the staff they hire for themselves, people who have the skills to help them to do their work. My comments will be two on this issue of companies in Kenya. I think we really need to make sure that and give them an opportunity. But the second one, I think, and I'll be looking to speak with the honorable member of majority, is that the private sector in Kenya, once we put for them a good system for doing their business, really helps to realize a lot of the goals we have in Vision 2030 in the government manifesto. And when we talk about issues such as education, where we are saying right now, in the next few months, that the reality of free secondary education will be important, I think this is something I'm going to beg the Leader of Majority to make sure, maybe miraculously, maybe through serious legislative gymnastics, we don't leave this House without having passed a law or an amendment to the Basic Education Act, clarifying the procedures in which we will spend the funding for free secondary education. The fact of the matter is free secondary education is something we all agree on, but the government schools in Kenya provide only half of the capacity. Half of the children in Kenya, whether they are in Nairobi County or Kisumu County or Garissa County, they are going to schools that do not belong to the government. And if we want to give them free secondary education, we will have to engage in public-private partnerships. So I think really in the sector of education, we must make an amendment to the Basic Education Act that covers up to Form 4, and we make sure that even people who own schools in Garissa that are not government schools, when it comes to a time for implementing free secondary education, there will be a legal framework for the government to engage them, to be partners on this, because the government just in the next few months, whether it's January or September, will not have in place all the schools it needs to make sure children can go to free secondary education. And if we put preemptively a legal framework or amendment to allow for those PPPs in the education sector, it will really help us, and it will give the government, come September or come January, the free hand to do things legally and finance public-private providers of secondary education. With those few remarks, I beg to support. Thank you.
Well, it looks like there are no other contributors, because the member for Seme has already contributed, the member for Ndiwa has contributed. Leader of Majority, I think it's only fair that the mover be called upon to reply.
Yes, Mr. Speaker. Mr. Speaker, on the onset, I want to thank my colleagues for their immense contribution. This is just a few amendments to help improve on the operationalization of the Companies Act 2015, just to make sure that we tie the knots and create a very strong corporate governance in how both public and private companies and those listed in the stock exchange are managed. Secondly, Mr. Speaker, and Kenya being a country under the leadership of President Uhuru Kenyatta, a country that wants to attract investment, then it's imperative that all the laws relating to companies must be in line with the global trends and the global best practices. So these amendments basically are geared towards that. where we expect, directors to make full disclosure and shareholders have remedies in the event to a collapse of a company, in an event where a director, the extent to which a director can cause a liability to that company. Mr. Speaker, I totally agree with Honorable Neto, my very good friend from the last parliament, that the definition of a spouse, there are many definitions, and there are many ways you can describe your other half. So I am ready to accommodate his other definition, whether you call it partner, pango wa kando, you can call it. So Honorable Neto, I think I said, but on 51, Honorable Neto, I think that from the time we passed this law in 2015, was enough grace period for companies to regularize their systems and registration under the new act. So the transition clause that we provided then, I'm sure in 1.5 years or 2 years, have served all the companies that existed before the coming into effect of this law. So I think that's why it's a cleanup exercise where we don't want to have a transition sugar level and everything is going down. So you'll excuse me, but I beg to move.
Very well, Leader Majority. Of course, for reasons well known to the members, we defer putting the question. Then we move to the next order, resumption of the debate.
Order number 13, the Constitution of Kenya Amendment number 6, Bill, National Assembly Bill number 65 of 2015, second reading.
This is the resumption of debate? Or you are not contributed? Very well, Leader Majority. It is, this bill is known by your name.
Yes, thank you, Mr. Speaker. Mr. Speaker, I didn't contribute. My colleague, Honorable Kato Olemetito, moved and members contributed, but now it's my opportunity to contribute to this Constitution of Kenya Amendment Bill number 6, Bill 2015, which is known as the Duale 2. Mr. Speaker, the object of this bill is to amend the Constitution to give effect to Article 81, subsection B of the Constitution. And what does Article 81, subsection B stipulate? It stipulates that not more than 2/3 of members elected to public bodies are of the same gender. And so this bill is to ensure that members of the National Assembly and the Senate conforms to the 2/3 gender principle as anticipated in the implementation of Article 81, sub-article B of the Constitution. Mr. Speaker, this bill is similar to the bill published by the late Mutula Kilonzo Sr., a man I respected so much when he was the Minister for Justice and Constitutional Affairs, predominantly dealing with the county assemblies, in as far as gender equity is concerned within the reading of the representation of the county assembly. So, Mr. Speaker, when I read this bill, which is under my signature, clause 1 and 2 provides for the application of the bill and how it's to apply to the general election. And the Speaker, this bill is before this House because we tried once, twice, thrice. We faced a lot of challenges. But leadership is part of the challenge. And every leader must have a solution to the challenges and the problems that face any nation. So we will try, and respecting the independent institution of the judiciary is what has made us to bring back this bill, so that at least I can walk and the House can walk the moral high ground that we are an institution that respects the rule of law and the institution of the judiciary, and that we republished this bill. Mr. Speaker, Clause 3 of this bill intends to amend Article 90 of the Constitution and to reflect amendments proposed in 97 and 98. And it further provides that any person who is elected to any House of Parliament or any legislative assembly by way of nomination shall enjoy such a nomination to a maximum of 2 terms. It means, just like the president, if you are nominated twice, then you will not be eligible for the nomination of, the 3rd nomination. I think now they are doing 28% of the membership of the House of Commons, if I'm not wrong, is of one gender. And that is the best, is of the female gender. And that is the best the UK Parliament did in many years. The only time that they surpassed that ratio was when the Prime Minister at that time, I can't remember his name, and also the party leader of the Labour Party, used proportional party representation, in which he said, in all the constituencies, constituency X is for the male gender, constituency B is for the female gender, so party representation. And that Prime Minister and that party leader then did not survive the next election. Now they are 28%. Tomorrow they are going to election, the House of Commons, the UK. I hope they will increase their numbers. So, Mr. Speaker, Clause 4 of this bill further seeks to amend Article 97 by inserting a new clause to ensure that the special seats are allocated proportionately to the number of seats won by a political party under the provisions of the new clause 1CA will lapse 20 years from the date of the first general election after the commencement of this provision. So basically is what the Labour Party then did to increase its numbers of one gender to get the gender equity. Speaker, Parliament may, however, by legislation, extend that sunset clause. Mr. Speaker, Clause 4 further specifies that legislation made by Parliament must be supported by not less than 2/3 of the members of the National Assembly and not 2/3 of all the county delegates in the Senate. Because it's a constitutional amendment, for us to dispense of this law, then we must have the 2/3 number required. Finally, Mr. Speaker, on the bill, Clause 5 seeks to amend Article 98, Sub-Article 1 of the Constitution by only inserting a new paragraph called DA. And this is to ensure that the Senate, as the House of Parliament, complies with the principle that not more than also 2/3 of its members are of the same gender. So this is the principle, Mr. Speaker. We are not saying we are going to pass, but Parliament and the 11th Parliament is known for passing all the pieces of legislation in as far as implementation of the Constitution is concerned. The only pending bill is this bill. And Mr. Speaker, those of us who served in the 10th Parliament, we know the history of this kind of a bill. But I want to say that from our party nominations, particularly the Jubilee Coalition, we are happy to report to the nation that we have increased our numbers, the number of women leaders coming to the 11th Parliament from the Jubilee have increased by twofold. In Muranga alone, out of the, I think, 4 constituencies, or 5, there are 3 women who are nominated, including my good friend, Honorable Alice Wahome. Jubilee will be the first political party in the history of Kenya that will have a woman or 2 women governors in the name of, you can't say point of honor, you're standing. You have to sit in the first place. You're not in a market.
What is out of order, the Honorable Mili?
Speaker, she has to sit first on a chair.
That is
He's
all right.
on the, working on the always.
Leader majority.
We are not in
Leader majority. In fact, you are on a very good point. You are saying that women representation should be appreciated.
Thank you, Mr. Speaker, for reminding Honorable Duale that he is not the Speaker of the House. He is majority leader. And I'd urge Mr. Speaker that he sits down when Honorable Millie Odhiambo, MP from Bita, is talking, because that is the standing orders of this House, that Honorable Duale cannot stand when Millie Odhiambo is speaking. Having said that, Mr. Speaker, is Honorable Duale in order to allege that Jubilee will produce the first woman governor, when we know that Wavinya Ndeti of NASA will be the first woman governor of this country, Mr. Speaker? Let him know that we will produce the first woman governor, but do we say?
It's all right, members. It's quite in order for. I think you are both beating the same drums.
No, Mr. Speaker, I don't speak for NASA.
Yes.
I don't speak for NASA. I speak for the Jubilee.
Yes.
So
it's
if
quite
she
in
wants
order.
to speak
Let's
about
proceed.
so and so called Wavinya Ndeti, it's quite in order. You'll have your time. I am talking about my fellow Jubilee nominees. And mark my word, inshallah, 2 women, one Dr. Joyce Laboso, the other one Anne Wamboi Waiguru, will be the next governors. And in the Senate, Jubilee will produce the first 2 women senators. One in the name of Susan Kihika, a daughter of a very prominent octogenarian politician from Nakuru, and one who served with me in last parliament and was a robust minister for education, Honorable Margaret Kamar. If there are some from NASA, they will have their owners to say it. It's not my business. And Millie Odhiambo, I don't speak for you, you know. And I'll never speak for you because of, you know, many reasons. So, Mr. Speaker, having said that, and Mr. Speaker, you know I'm fasting. And when I'm fasting, she wants to pick a war with me. But Mr. Speaker, I am fasting because I'm a serious believer in Islam. I don't know whether Honorable Millie Odhiambo, is she SDA? Is she AIC? Is she Dinia Musambwa? Is she Catholic? Oh, you are a Catholic. Oh, okay. So, Mr. Speaker, the Jubilee Coalition, if you look at our numbers, progressively, it shows we are more committed to increasing the women leadership in both houses. And Mr. Speaker, one of the reasons that made me put my signature, apart from being the leader of majority, on this and support the cause of women, support the cause of the great women, including my mother and my wife and my sisters and my deputy, and including my friend Millie Odhiambo, is because many of us here, me included, we are here and we have reached where we have reached because of our mothers. I am sure everybody here, mothers played a very, very big role, and I am a living example. Secondly, when President Obama came to Kenya, of the many things he said, you can't have a team that is not playing in the field. They're always at the bench. The women leaders in this country must be given their space as provided for in the Constitution. And the president, as our party leader and as the president of Kenya, he is committed. All of us who work with him are committed, and I'm sure under his leadership, in the 12th parliament or in this parliament, Uhuru Kenyatta will sign, will append his signature into this law. Either now or, of course, the 12th parliament, because there's no doubt in my mind that the next and the 5th president of the Republic of Kenya is none other than Uhuru Muigai Kenyatta, the son of the founding father of this nation. I beg to support.
Very well, Leader of Majority. I think we are all speaking from the same script by beating the drums that we need more gender representation from the women's side. There's no cause for alarm to quarrel with the Honorable Millie. I've not heard the voice of the Honorable Agostino Neto for quite a bit of time. I think I want to give him this opportunity to speak to this.
Thank you, Honorable Speaker. Honorable Speaker, indeed, it's a nice thing to see you in the chair in the dying hours of this particular. Honorable Speaker, you know, an interesting thing is when I was joining this particular parliament, the first bills that I was championing was the 2/3 gender amendment bill. And I did come together with my colleagues, Honorable Ken Okoth, Honorable Abdullahi Dirie, Rachel Ameso, Stephen Mule, to ensure that the spirit of the Constitution under Article 27 is realized. And we did move together in the spirit with other members of civil society to try to champion the Green Amendment campaign, which we, of course, start very robustly at the end of this year after the elections in August, Honorable Speaker. The reason we're doing that, Honorable Speaker, was to ensure that those constitutional principles, the rights under the Kenyan Constitution, are not just pies in the sky, that they're the principles and the rights that are realizable for whosoever the rights are so accorded. The rights of women in this country, Honorable Speaker, with regard to election is a story that is painful to tell, because you find members of the female gender struggling for elections with men in various spheres, and it's very difficult sometimes to get most of them elected. And so when you see Honorable Dr. Shaban, Honorable Millie Odhiambo, and very many other female members of parliament who are here, just know that they're not the ordinary type of ladies. They're people who've worked hard to get elected, because even many men do get defeated in these elections. And so for the women to be elected, I really think most of them do deserve pats in their back. Honorable Speaker, this particular bill that the Honorable Majority Leader has brought has fundamental flaws. Flaws that I really think need a lot of consideration. Whereas the spirit of this particular amendment is good, I really do not think that the person who drafted this particular bill read through it, Honorable Speaker. Because Honorable Dr. Nyikal, not being a lawyer, but is an intelligent doctor who I think has the philosophy of both law and medicine, has engaged me with, in serious legal discourse. And to that extent, we've actually agreed that the phrasing of Clause 4 of this particular bill, I think, is not a very good phrasing. And I think, actually, it is one that cannot be realized. It's unrealizable. even though you want to pass this bill in this particular form. And, Honorable Speaker, I think there is a perception that this particular clause 4 is the same as the principle of Article 177 of the Constitution. That is not. And I think having discussed with the Honorable Dr. Nyikal, we agreed that it is really not. There are two different sides of that particular thing. Because, Honorable Speaker, a reading of Article 177 of the Constitution talks about the entirety of the County Assembly, so that it is not just a single clause. You see the problem with this particular clause 4, it talks about Article 97.1. Article 97.1 deals with the election of 290 members of Parliament. But you see, that does not take into consideration the entirety of the House, both the National Assembly and the Senate. So then what you have is a problem, Mr. Speaker, with regard to tweaking the numbers. It will be difficult to realize what is 2/3 if you deal with 290. But if at all you're dealing with the entirety of the House, which is the entire Article 97, then you have a solution. And that is why the person who drafted this particular clause really needs to reconsider it. We might pass it, but even if we pass it, there's still a problem with regard to attaining and achieving the numbers. So I really think that the person who really did this copying and pasting did not do a very good job of copying and pasting. I really think it needs to be considered, Honorable Speaker. So whereas we agree that the spirit of realizing rights in the Constitution is a good spirit, I really think that the drafting of this particular section is not really good. The second thing, Honorable Speaker, is with regard to the sunset clause. Of course, all affirmative action clauses ought to have sunset clauses, and I really think it's important to agree that an affirmative action clause with regard to gender ought to have a sunset clause. But, Honorable Speaker, if you look at clause 4.1c, with regard to a total of 20 years lapse, and then a further 10 years lapse, Honorable Speaker, I really think that is too much with regard to affirmative action. I really think, let's be honest, let's be fair, that within 20 years, we are able to put in principles within political parties, we are able to give capacity to women, we are able to make sure that the women have free competing space without really thinking that in 20 years, we still need to have them affirmed. Because I really think what we've watched in the 2017 election, and of course, Honorable Duale is already excited that his party is going to have governors. Of course, I'm sure the party that I'm going to belong to in the next parliament, which is the Party of Independence, might have many more governors and senators or members of parliament. But, Honorable Speaker, I really think that one of the things we need to appreciate is that we must do whatever it is possible, whatever it takes. We must look at political party nominations in a manner that makes sure that we have many more women within that particular sphere. If we conducted political party nominations the manner we did the last ones, you can be so sure that it does not matter how much affirmative action we do, we still end up with very few members of parliament who are women because of the intricacies of the various things that you have to do. So I really think that the sunset clause is a good thing, but I really think giving it 20 years is slightly too much. The third thing, Honorable Speaker, I'd like to speak to is with regard to how to achieve affirmative action clauses. You know, law is a social science. So science has formulae, and you cannot pretend that you want to guess how to attain certain things. If you want to achieve the truth agenda principle...
Boneto, just for my own clarity on this, you have a problem with the sunset period of 20 years, or do you have a problem with the provision that it may be extended by another 10 years?
I have a problem with the extension.
The extension of 10 years.
For 1D of an extension of 10 years.
So you would be happy if it just closed at 20?
20 is fine. If at all we stop at 4.1c to say that there shall be a sunset clause after 20 years, because then, thank you so much, Honorable Speaker. Honorable Speaker, the third thing I wanted to speak to was the fact that I was saying that law is a social...
Viti wakati wa uchaguzi na haswa viti vya bunge la kitaifa, bunge la Senate, pamoja na bunge la county. Mheshimiwa Spika, ukweli ni kwamba Wakenya bado wana tatizo la kuchagua kina mama, na haswa pia walemavu na hata pia vijana. Kwa mila na desturi za Wakenya, Mheshimiwa Spika, ni kuwa kuna viti ambavyo vinaambiwa vinafaa jinsia ya waume na kuna vile ambavyo haswa sisi wa jinsia ya kike tunaangaliwa kijadi katika maeneo yetu. Lakini inawezekana kuwa kina mama wanachaguliwa. Kwa sababu Mheshimiwa Spika, nimechaguliwa mara ya 3 sasa. Na inawezekana kuwa si mimi peke yangu, kuna wengine pia walichaguliwa hapo mbeleni. Dadangu Mili Mabona amechaguliwa, kina Martha Karua walichaguliwa, kina Charity Ngilu walichaguliwa, kina Beth Mugo walichaguliwa. Yani wengi wameshachaguliwa, lakini sio wengi vile inavyotakikana kwa mujibu wa katiba yetu hii ya Kenya. Kipengele cha 97 na 98 kimezungumzia umuhimu wa kuwa na kina mama, hata ikaika makusudio ya kuwa kina mama wapatiwe viti ambavyo watavigombania wenyewe kwa wenyewe ili tuweze kuongeza idadi ya kina mama kwenye viti vya uchaguzi. Lakini vile vile tukiangalia kipengele cha 81 ambacho kinachozungumzia umuhimu wa kuwa hata kwenye bunge za kitaifa na bunge la county ni kuwa watu wa jinsia moja wasipite thuluthi 2 za jinsia, ili thuluthi ile ya 3 itakayobakia iweze kuwa itapatiwa wale ambao ni wanyonge na hawakuweza kupatiwa nafasi wakati wa uchaguzi. Viti hivi ambavyo viliwekwa haswa vya maalum vya kina mama, vya kupigania kina mama kwa kina mama, viliwekwa pale kwa makusudio ya kuwa watu watavitumia baada ya miaka 5, muhula huo ukiisha, wanaweza kusimamia viti vile ambavyo ni vya maeneo bunge yale ya kawaida, yani 290. Lakini tulivyoangalia juzi katika hali ya kuchujana, tumeona kweli kuna kina mama wapya waliokuja na kuna wale pia ambao waliokuwa kwenye vile viti ambavyo vilikuwa maalum vya kina mama na hawakuweza hata kupatiwa nafasi kuweza kuendelea kupigania hapo, na wale wengi waliojaribu kwenda kwenye viti vya maeneo bunge yale 290, wengi wao hawakupatiwa nafasi ya kuweza kupigania viti mnamo tarehe 8 mwezi wa 8 mwaka huu. Hivyo basi ni kuwa bado mila na desturi zetu zimekuwa na matatizo, na kwa sababu ya tatizo hilo kuna umuhimu wa sheria hii kubadilishwa ili kuhakikisha kuwa kina mama wanaweza kupata nafasi, walemavu pia wanaweza kupata nafasi, na vijana, na haswa kina mama ambao wana shida, wana uzito wa kuweza kuchaguliwa kwa urahisi. Moja kwenye katiba yetu ya Kenya inazungumzia kuwe na makusudio ya kuangalia kuwa kina mama wamehusishwa, walemavu wamehusishwa, vile vile vijana wamehusishwa. Kipengele cha 100 kinazungumzia masuala yale. So inatubidi kuwa tuangalie kurekebisha kwa katiba hii, lakini vile vile tuangalie kama kuna uwezekano wa hicho kipengele cha 100 kuwezeshwa ili tuweze kukitumia kuweza kupata idadi ya watu vile inavyotakikana. Kama ninavyosema, mimi kwa upande wangu nilikuwa nimeona kuwa ingekuwa rahisi kama asilimia hiyo ambayo inayotakikana ifike ingeweza kuangaliwa kwa muda wa miaka kadhaa ili iweze kufikishwa idadi ya haswa kina mama, ya jinsia kina mama ya vile inavyotakikana hapa bungeni. Mheshimiwa Spika, kuna umuhimu wa sisi kuyazungumzia masuala haya, kuna umuhimu wa sisi kupitisha sheria hii, kuna umuhimu wa sisi kukubaliana, kwa sababu hata viongozi wetu wa vyama vyetu vile ambavyo vimetuleta hapa, wote wameshasema wazi hadharani kuwa kuna umuhimu wa kuhakikisha kuwa kina mama wanahusishwa kwenye bunge zetu za kitaifa na vile vile bunge la county. Ningekomea hapo, lakini nikisema kuwa ningeomba wenzangu wote tuhusike, tuweze kusaidiana, tuweze kuangalia njia swala hili linaweza kutekelezwa. Mheshimiwa Spika, asante sana kwa kunipatia nafasi hii.
Very well spoken. I just wish that the Honorable Neto had listened more closely to what you are saying, because you've spoken to the issue of the sunset period for the provision that we made for this this particular. But the Honorable Neto has difficult with Swahili, so I hope the Honorable Koth will be useful to him in explaining to him what the Honorable Shaban has said in very lucid Swahili. The Honorable Koth is not your chance yet. I would like you to explain to the Honorable Neto what the Honorable Shaban has said. I will give this opportunity to the Honorable Nyekal, the member for Seme.
Thank you, Mr. Speaker, for giving me the opportunity to discuss this extremely important constitutional amendment bill. Mr. Speaker, this is a bill that actually demonstrates the whole issue of how we should implement our constitution, realizing that we may have extremely good principles in the constitution, but have problems with their implementation depending on how the laws or the constitution itself was laid out. Mr. Speaker, this is based on a principle that all of us are agreed on, the principle of equal opportunity for women. There's no doubt about that. The whole country is agreed women are 50% of the population, therefore they deserve their opportunity. The issue of affirmative action for women, that is all agreed. Women have been faced with a lot of impediments and disadvantages, starting with historical facts of laws, of culture, of etiquette that really tended to lock them out. But even more important, the role of women in the society, the big role. Women do a lot of unpaid work. Just the issue of childbearing and child rearing is such a big issue that many women actually cannot take up positions because they value that at the utmost. So those who want to take positions need to be supported. So the issue of affirmative action, there's no problem. People are agreed. When we come to the two-thirds gender rule, that's where we start to have a problem. In Article 27(8), Article 27, I think subsection 8, which says 2/3 of appointive or elective positions. That is where we start to have problems. When you look at appointive positions or appointive bodies, there's no problem because you can achieve numbers through appointment. But then when you come to the elective bodies, it becomes difficult. So when you go to Article 81B of the Constitution, which now states categorically 2/3 of elective bodies. Now we then start to have a problem, Mr. Speaker, because it is virtually impossible to predict numbers through an electoral process. And that is why we are having this problem. Even if you have the sunset clause in 20 years, 10 years, that does not solve that problem of achieving a certain number through an electoral process. So, Mr. Speaker, we tried with Article 177 in the case of the assemblies, and then put that we will have special seats to ensure that the assembly, in the case of the county assemblies, 2/3 are not of the same gender. And that is achieved by appointing these 2/3 after the election. But Mr. Speaker, we have a problem with that. The problem we have with that, Mr. Speaker, if we use exactly the same as we have in Article 177, then we're actually going to have a very large number in the assembly, which we seem to be afraid of. In fact, it will be as large as probably 450. The Honorable Shaban, we did this with her in a committee, and that's what happens. So, Mr. Speaker, when now we want to use Article 177 and say we appoint people to fill the numbers, then we are faced with a very large assembly. large number, which is over 450. And as a country, we are afraid of that. So now we come and we are attempting to get that number perhaps smaller by bringing this bill, which I support. But Mr. Speaker, again, I want this to be listened to. Honorable Neto said it. What is proposed here is not the same as what is in 177. And it has a problem, Mr. Speaker, because what is being proposed, if you look at Article Clause 4D, I think Clause 4, we are getting CA, which says the number of special seat members necessary to ensure that no more than 2/3 of those members elected under Clause 1A are the same gender. Mr. Speaker, look at 97 Clause 1A. It is talking of the 290 and not the whole assembly, as is the case. As is the case with Article 177. So in this case, we are talking of 2/3 of 190. And I don't see how, even if you pick these people, you will ensure that they're actually 2/3 of 290, which is what Clause 97(1)A is talking about. So there's a technical problem there, to the extent that even if we went through, we may still have a problem, because those seats are already there and they're going to be contested. So you cannot again determine their 2/3. 177, which you are copying, is talking of 2/3 of the assembly. Now that's where the problem is. And the same is repeated in Clause 5, which is also indicating that it will be the number of special seats necessary to ensure that no more than 2/3 of the members elected under Clause 1A, but that is again 1A of 98, Article 98, which is 47 seats. So again, those seats are set aside. They are going to be contested, so I don't see how this selection after the election is going to give you their 2/3. So, Mr. Speaker, we have not exactly imported 177 into 97 and 98 as we intended to do. So if that can be looked at technically and that resolved, then I think this bill will solve the problem. So, Speaker, I do realize and appreciate that these special seats will be identified after election. That is the only way you can do it, other than having proportional representation at the constituency level, identifying constituencies that will give you 2/3. We have not gone for that. So what we have proposed, if that is worked out, will actually help us out. I do appreciate and also accept that their terms are limited to, their term is limited to 2 terms. I appreciate that. At least they'll get the
Honorable Agostino Neto. What is out of order?
I just wanted to point it out to the Honorable Nyikalo. Of course, I don't want to interrupt him. He's my senior. I just wanted to help him understand that proportional representation is not with regard to particular constituencies, but it's with regard to political party strength. Then they can align it to whatever representation that they want. Thank you, Honorable Speaker.
Very well.
Well, I think the word would help us even if you apply it to constituencies as well, but I accept that.
Very well.
So that I think that the sunset clause have indicated if we do not correct that numbers issue, then even the sunset clause, who says after 10, 20 years, things will change? So I think that is something we also look at. But as I've said, this indicates the problem we have in implementing the Constitution that is well intended. And I'm happy that the chair of the CIOC is here. That is the Constitutional Implementation Oversight Committee. I think it is time that this committee, at the other body, sat down and started looking at our Constitution line by line as we implement it. And where are we meeting problems? And look at ways of actually correcting them through amendment, even if it means referendum. With that, Mr. Speaker, I thank you and I support this bill.
The Honorable Nyikal, I think you raise a fundamental point, and I've just urge you to look at it with a view that as we go forward with this proposed amendment, that you can bring in a further amendment together with the chair of CIC, so that we can have a clean bill, so that our women, when they come to this house, they'll be well anchored in the law. I will now give this opportunity to the Honorable David Gikaria, member for Nakuru.
Thank you, Mr. Speaker, for giving me this opportunity to air my view regarding this constitutional amendment. Mr. Speaker, I'm also a member of the CIOC, and my chair is here. And this is one of those legislation that was not implemented as per the Constitution, because I think we cleared with all the other laws. And it was unfortunate, Mr. Speaker, that it has taken that long. We've had so many other interactions with our colleagues, the women member of parliament. At some point, on 2 occasions, they did invite us in some meetings to try and mobilize and be able to make us understand the sense of having this. But Mr. Speaker, I don't know how possible also these amendments will see the light of the day. And I'm saying this in line with the very, very tough constitutional provisions of the 2/3. If we have to raise 2/3 to be able to amend, of course it's a constitutional issue. And we also need to look at it, that the threshold of passing this legislation is also very, very stiff. It is just, and people, most of the time, could easily be whipped to defeat the motion because they cannot be able to attain the 2/3. Including the sunset, the additional 10 years also requires 2/3. That one, I think, is in order, so that it can be made difficult not to add the 10 years. But the law as it is and the Constitution as it is, leaving it at 2/3 for us to be able to make this constitutional amendment, then it is a very, very tall order for us to be able to attain that. Mr. Speaker, it is also now increasingly becoming difficult, even at the county assembly level, going and basing the argument, even at the county assembly level, to be able to attain the 2/3. And I'll give example, for example, in Nakuru County, or rather in this elective period, that the current of 2013-2017, we had 8 women who were elected as members of the county assembly. But now, in all the other parties, and I'm not saying, because now going by the regional issue in Nakuru, being more of a jubilee place, and we have, the number has reduced only to 3, which means, again, the nomination of one person for every 3, because there are 55, which means they can only go up to, I think, 19. Again, now it means even if we nominated 19 women, we will still not be able to attain the 1/3 gender rule at the county level again. Again, these are some of the issues that we really need to look at. Of course, during the interaction that we had with our dear lady members of parliament, the issue of the 290, as ably said by Honorable Nyikal, was raised. And we really wanted, is it the 2/3 of the total number of National Assembly or the Senate, or is it the elective position of the 290? And Mr. Speaker, that takes me now again to Article 97, which gives specific number of members of parliament at 290 constituencies, and 47 women elected from each county, and then 12 number of nominees. Of course, this is going to really affect. And since this is so, it is specific, again, we need to look at whether Article 97, and that is for the National Assembly, and Article 98. I've been trying to, I didn't have the bill. I was trying to go through the majority leader's briefs. I don't know whether they have been amended, the two articles, because again, it is important for us to look at, because they are very specific as to the number of members of parliament who are supposed to be at the National Assembly and even at the Senate. So it's important for us to holistically look at the amendment, look at the other clauses within the articles within the Constitution that also needs to be critically looked into so that we can be able to actualize the effect of this amendment. Honourable Speaker, you remember the ruling by the court which gave the Parliament 60 days, the National Assembly, I think it was Parliament, 60 days to have, legislated and passed this law. And it's also an issue now. Assuming it is not passed, does the same constitutional provision that if you don't pass, because already the period lapsed, if you don't pass, assuming in the 12th Parliament, again, it is not, this law is not amended and passed by Parliament and the Senate, by Parliament, then what happens? Again, will the same law again be applicable in terms of that Parliament will stand dissolved if we don't? So it's a matter that we really need to look into. Of course, the provisions which have been given in the amendments are quite in order, where, of course, we really need to look into how that, and particularly the 20 years. Honorable Chepkonga had brought his amendment. I don't know whether it is still a property of the House. And it had actually addressed some of these issues. In terms of how we will stagger this within the 20 years. I also agree with Honorable Neto that an additional 10 years, I think it has been given a very high threshold, and it might not be possible to push to another 10 years, which is something that is... So I think we will need to look at this holistically in the third reading so that we can be able to bring the amendments that, and also look at the other articles within the Constitution that we'll also want to see. And more so, Mr. Speaker, and I want to repeat this, is that the threshold of the 2/3 to be able to amend is very high. And we might never be able to. Of course, we call upon our male colleagues to support. I was one of those people who was whipped in the last attempt to get out of the House so that we could not be able to. And I'm hoping that the male and female members of Parliament who will be elected in the coming election will be able to support this very important and give our women an opportunity. But at the same time, Mr. Speaker, and this I want to make it very clear, that it's upon the women also to take up the challenge, that we cannot have 47 women representing counties, and most of them are not actively participating in the actual proceedings of the House. I think it's also, and I know, and I'm saying this, it's unfortunate that a few of them, it doesn't matter. You don't need to debate in a House to be able to be seen as if you're active. But I think we need value for the space that they are being given. It would be wrong just to have women being nominated to come and sit and I don't want to say to earn salary or allowance and things like that, but I want to see women participating in the actual management and development and political aspect of this country. With those few remarks, Mr. Speaker, I support.
The Honorable Gikaria, you have got no fear for the next Parliament in the event that they will have the same amount of time and the same provisions as to whether they can put in place the necessary laws to bring these numbers into the constitutional consideration. But I think we must give this our best shot as this parliament, and that is what we are doing now. We should not operate in a fait accompli mode, but we should be hopeful that we can do our best and come up with a law before we adjourn the House in a day. So I will therefore give this opportunity now on the basis of seniority in terms of just age. I know it is Kenneth Okot, but I can see he's still consulting the Honorable Neto. I will therefore allow the Honorable Sakwa Bunyasi to go before him.
Thank you, Chair. There are chronological advantages in life, and I appreciate to have this one. Mr. Speaker, sir, I think the proposed amendment is fundamentally sound. I have absolutely no quibbles with the drive towards some form of gender parity as agreed for the time being, that no more than 2/3, therefore seeking to have just 1/3 of the other. In nature, it's of course about 50-50. And that should happen naturally. That's not where we are headed right now. Hopefully it will come by itself in the long, long run. But right now, Mr. Speaker, this is just a minimum one I think we can aim for. So let's go for it. Having said that, my colleagues have already hinted to the mathematical problem of how the drafting was done. I think basically, if we are seeking to achieve outcomes right from where we are now, we should say the National Assembly has 290 members in the various constituencies. We cannot predict how many will be of which gender as they go into the August election, for example. In the August election, we'll have 47 women as well that will be elected. They are going to be women. We know that number. We also are going to have an additional 12 people that are going to be nominated, represent various interests, but they have a gender. What I would suggest, Mr. Speaker, sir, that if you are truly trying to seek a composition in this House to conduct business in a way that includes all these genders in the proportions we are seeking to achieve, then we should start by saying, after we know, and of course this has been referred to in various clauses of the amendment and in the Constitution, after we know the composition of the 290, we have 47 we know will be of the opposite gender, certainly, to the majority in the 290. And then the 12 also that are nominated are also going to be various genders. Then, for purposes of the parity we are seeking, the number that balances the ratios in accordance with the minimal standards that have been agreed must take that totality. So it's not just referring to the 290, it should be referring essentially to the parliament as will have been constituted in accordance with the clauses that are in 97-98. That produces slightly different arithmetic, but it means that we can conduct business beginning in the 12th parliament with a stable, proportionate representation that over time, as we phase out the 47 women, which will happen, I think 20 years after the 11th, including the 11th parliament, no, starting with the 10th parliament, 2010, that we shall have now begun to work increasingly with a greater representation of women and not wait for a time period in 10 years or in 20 years and then 10 years. It's not an event that will happen at one specific time. It's a process that produces that outcome. Having said that, Mr. Speaker, sir, that I hope we'll pay attention to the baseline that we are comparing with. This we can do in the amendments right away when this time comes up. I think, Mr. Speaker, sir, the reason we are not there yet is that even in nature, representation is not done that way. And in our political setup now, we have many impediments outside of this arena we are debating that partially contribute to this outcome, that result in the outcome we're looking for. And we must address those. One, issues of the cost of campaign financing is run away. And we know that in our societies, the distribution of wealth is uneven. It's uneven for various reasons. There may be cultural reasons, there may be legal reasons, there may be other reasons also that, that lead to that. We must address that fundamental issue so that we reduce at least the impediments related to the highly distorted distribution of wealth in our societies, which comes at play when we come to elections. It doesn't just affect women, it affects younger people who have not had a chance to accumulate wealth of their own, with some exceptions, like the gentleman who apparently was nominated, who is Branamboga, but he got nominated, one watchman got nominated on the assumption that a watchman has lower income levels than the average person in other spheres of life, or Mamamboga, for example. So there are issues that mitigate against women, mitigate against youth, that we need to address, including campaign financing for starters. That's one. Two, we must act firmly within even the existing law, through implementation of the law, to ensure that words and actions of hate, because these hates may be cross-ethnic, these hates may be gender-related. People say all manner of statements. I remember in the first election I participated in, some of my supporters in Busia, who are of the Somali origin, and who are concerned about the nature and interaction they can have with men, and when people realize that even rubbing shoulders alone would scare them, they would go and touch their breasts. Terrible thing to do. And they didn't show up. You report this to the police, they look at you like, okay, then really what do we do? We must get serious with that. If we address issues like that, physical violence, verbal violence, issues of hate, and so on, we'll encourage more women to come out. I mentioned the issue of violence. Too often, violence now has just become simply as a matter of an election. It's a normal thing, an election. It's not normal. It's not part of an electoral process. If we begin to address those, we shall stabilize the base on which the gender issues can then be addressed, on which the outgrowth of women to get into politics will now become a natural phenomenon, and the chances that the next person will want to run will only be in proportions related to population. That will be a man or a woman, will only be in relation to the general population, and not in these other mathematical numbers that we have to work on, and yet we do not have a process to produce that mathematical outcome. Mr. Speaker, sir, I really think that this drive towards gender parity must be pursued. One is that the reaction across genders, the issues, the challenges that we face in life are different. If you had more women taking decisions, making more decisions in our public life, using our public resources, decisions about, for example, sustained hunger each year, 1 year after the next, might also be addressed differently. In my own community, I know for a fact that most men wake up in the morning, they might go to the market. Of course, they seem to have projects at the market. They will tell you they're going to try to earn an income. The truth is that they're not going to go to the garden where most of the resources are derived from, where income is derived from, in the terms of food and other crops that they may be growing, or maybe livestock. And therefore, if you do not get into a situation in which these choices are normalized in accordance with the population, we're going to continue to get these challenges that we have got. I think that these numbers we are seeking, it should be the dead end of the process. And sure enough, we want to define what we want to achieve in 20 and 30 years, but the truth of the matter is that the numbers that result are an end result of a process, they're a derivative from some conditions. These ground conditions will be different. So as I was saying, for example, the issues of how we allocate our resources towards food security, to forestall the famine and deaths that occur. If women were half of this house, we would be making completely different decisions on that. We would not be waiting to import maize at exorbitant prices when people have already died. They might remind us of that a bit earlier. There are ways in which different genders make decisions. Mr. Speaker, I oppose the extension of 10 years. I think that we must seriously begin to address this now. And 20 years is a long, long, long time. I think extending it by 10 years, okay, why not make it 50? Why not make it a century to come? You could do that. After all, if we look at what other countries have done, including, say, the Scandinavians, advanced as they are, they haven't reached it. The British, where we inherit our parliamentary democracy, haven't reached it. Why don't we make it 100 years? I don't think that's the direction to go. We could go the other direction, like Rwanda has done, like South Africa has done. We don't need 20 years to make the decisions that Rwanda has made. Let's get serious on this. But first and foremost, let us define what we are seeking to achieve more clearly so we can begin to see where we are come September. Thank you, sir, Mr. Speaker.
Very well spoken, a member for Nambale. I would like us to proceed in this way. I can see the chair of the committee that really is the mother of this amendment, the Honorable Njoroge Vaya. I would like you to be the last person to speak to this so that you can listen to what the other members are saying, and then in that way you can speak to all the matters that I've spoken to. So I will therefore allow the Honorable Ken Okoth to speak, and he will be followed by the member for Butula, and after he speaks, then the chair for the committee will speak.
Thank you, Mr. Speaker. I rise to support the amendment and to make my remarks on why and give the context. I think we Kenyans often make the mistake of forgetting our history, even very recent history, so quickly, and find ourselves in a situation where we're dealing with issues as if we're dealing with them for the first time. The reality of the matter is that the push for equity and equality and justice and inclusivity in our political system is a battle that has been going on for a long time. When we go back to 2010, as the constitution we're using now was passed, which we've all sworn in this House to defend and to uphold, a lot of the debate narrowed down to was the issue of, is the Constitution good enough or to be passed as it is, or does it have some faults in it that should be fixed before it's passed? That was the question. Even the people who were in the no campaign, even the people in the yes campaign, even the people who were considered watermelons in between, everybody agreed that there is something that needs to be fixed in the Constitution. It's a living document. It's not perfect, as is the reality in many other places. But if we recall very clearly, and I want to put it again on record, is that the argument was on the no side saying 20% of the Constitution is bad and we should talk about it and agree on it and fix it before we pass it. And the people who were on the yes campaign said, yes, we agree, there's 20% that's not good, let us proceed and pass, and as soon as we've passed it, in the first 5 years we will review, maybe in the first 10 years we will review and put those questions and get to a consensus and come back to it. You know, the Honorable Agostino Neto and the Honorable Leader of Majority Duale today, it was remarkable for what they said in this afternoon today, and they'll go down in history. To see a leader of the majority and a member of the minority who thinks he'll come here in October as a party of independence member after, you know, my good friend Agostino said that when we talk about the definition of spouse, we should expand it. And they agreed. But this was a constitutional issue that was debated at that time. And we have had time in the last 5 years without too much pressure to fundamentally put these issues down and question them and say, what is the direction that Kenya will take on these 20% of the issues? I belong to ODM Party. ODM Party was amongst a group of parties and civil society members who came up with the Okoa Kenya movement. People are seeming to have forgotten that there was an Okoa Kenya bill which went and collected signatures to amend the Constitution. And that constitutional amendment bill that was proposed by Okoa Kenya included issues of how much funding to go to our county governments for costed, devolved functions. What's the proper formula? Upgrading or reviewing the nature and streamlining and bringing into line, for instance, the provincial administration, what used to be former, that is a branch now, the national government administration, bring it in line, if you're talking about wage bill, bring it in line with county government. County governments now have duplicated. You find we have a ward administrator, sub-county administrator, yet the national government has the same people, and you wonder, How many of these people do we need, and where could we streamline them and use them jointly and things like that? The Okoa Kenya bill did not, unfortunately, I will say this, it talked about a ward fund, it talked about the place of CDF fund, which are very important issues because we must devolve utilization of resources and bringing them constitutionally to the lowest level in a manner that's predictable. But it did not talk on the two-third gender rule. Now here we are on the two-third gender rule. The two-third gender rule must be accomplished. I think we all agree on that. Some people don't and are opposed to it. But I think it's a good thing. And I think to the women of Kenya is to tell you, your hope will not come through the 11th Parliament. This 11th Parliament I serve in has done many good things. But one bad thing it has not done, which will remain as a stain and an opportunity we had, because we did call quorum a couple of times. I remember a time when the Honorable Stephen Kalonzo Musyoka, the Honorable Raila Odinga were in the Speaker's Gallery while we were debating amendments for the two-third gender, and it did not pass. Now we are left with 3 days next week for this House to meet. So I'm telling the women of Kenya, your hope is not here, not in this 11th Parliament. It is a sad thing, but I must break the news to you. Number two is the women of Kenya must be ready to collect signatures, because there is no guarantee the 12th Parliament and the attitude of chauvinism and entitlement that when it comes to spending public money to engage a few more women to participate in our leadership, we are quoted a wage bill. But the amount of corruption that goes on in this country, just a fraction of that would be enough to pay for the salaries of any women we bring in here, whether we nominate 90 or 100 more. And while I'm talking about the wage bill, let us go to the reality of the matter and say we must choose to bite the bullet and face some hard choices. The Honorable Agostino Neto, at the beginning of this Parliament, in April or May 2013, brought to the Budget Committee and was stymied a very clear, simple, and clean bill proposing to reduce the size of the National Assembly and the Senate to make it affordable. So we can't speak out of two sides of our mouth. On the one hand, when you want to frustrate the women, you tell them wage bill. But in the first instance, the Honorable Agostino already brought a bill that's a proper proposed bill, a legislative proposal that was stopped as a money bill when it was proposing to reduce the size of government, including the size of elected officials, the number of constituencies, so that we would have a smaller parliament that accommodates and meets that two-third gender. It was rejected. So what is our stance really? And the Honorable Agostino was advised, it's a money bill and you may not proceed by reducing the size of parliament and making parliament smaller and more affordable. What was he told? He was asked, go come up with a better formula that increases the size of parliament. He did. When it came to this House again, Justice Committee, the Honorable Vaya is here, he knows these things, how they go. The Budget Committee, that I think got the nod. But it was never published and brought here for real debate. So I wonder why we pay bright minds like the Honorable Agostino to go do a proper bill, and then it's not debated. Here we are debating Duale 2. What happened to Duale 1? What happened to the Judith Jenny bill? You know, so here we are debating Duale 2 as a formality. And my reminder to the women and any good person of conscience who cares about inclusivity in our leadership, we are not going to realize this in the 12th Parliament. The reason we are discussing this is because Judge Mativo ordered that within 60 days we must discuss it. That 60 days expired last Monday. So any right-thinking Kenya is within their rights to petition the court and the Chief Justice to write to the President to dissolve this Parliament. But this Parliament is getting dissolved next week. So by the time you deliver the letter to the Chief Justice and he considers the matter and delivers us the same to the presidency, it will be, in vain. It will have been passed by time. But we're looking ahead to the 12th Parliament. And I'm hoping that more women will be elected on our parties. They'll make it here. That the first order of business, and I speak it to the members of this House and all Kenyans of good conscience, The first order of business in the 12th Parliament would be, let us finish implementing this issue once and for all. But let us also come up with a proper bill and law on the issue of referendums. Two issues stand out in this country on how we involve public participation and how we do referendum. It is not clear. Those, I think, are gaps that we're leaving in the 11th Parliament that I hope in the 12th Parliament, whoever will be here, will quickly address and say, what are the guidelines and the proper legislative basis for Kenyans holding a referendum? Number two is what constitutes proper public participation at the county assembly level and at the national government assembly level. Those are issues that we must address, because then we're left neither here nor there. But this issue will rear its head again in the 12th Parliament when we come in, because this is not going to pass. And we will come up with a house that is not properly constituted. And there might even be a constitutional crisis unless we proceed. Mr. Speaker, I beg for 1 minute. I see my time is running out. Unless we...
The Honorable, you'll have to...
Thank you, Mr. Speaker. Unless we proceed with our usual ways of impunity and ignoring things, the reality is that the 12th Parliament, once constituted, if it's not properly constituted, we'll have a constitutional crisis, and we'll either have to pass a formula or a new law that can work to make that house legitimate or not. I think we have seen the message to Kenyans is a lot of Kenyans are tired with the cost of government. They are concerned about the structures that were set up with this constitution, including some saying the number of counties is high, the number of constituencies is too many. We must have that dialogue, and it should be had maybe separately from the election, but it should be had soon. And I regret that in the 4 years that we've been here, we've not been able to have that dialogue, that even the proposal that Okoa Kenya movement brought, which could have been embraced and expanded, was never done. So it's a betrayal to the cause of inclusivity and equity in our leadership, but I am hoping we will make more steps going forward to make Kenya more inclusive, and we do need a clear law on issues of referendum, and we need clear guidelines on what constitutes public participation and when is proper public participation has been done to meet constitutional threshold. So it's not just done as, by the way, procedurally to check the boxes that public participation was done. Something was published in a newspaper, but you don't have the chance for members to really engage. So, Mr. Speaker, with those few remarks, again, I would like to note that I support the bill. I regret that it has come too late. I regret that we are doing it because our arms and have been twisted as a house by the ruling of Justice Mativo, and that we're not going to be able to pass it, and any Kenyan citizen can thus ask for the House to be formally dissolved, even though that's going to happen next week, and it's a shame. So the struggle continues. As we say to the wamama of Kenya, msilale bado mapambano. The struggle continues.
The Honorable Michael Onyura, the member for Butula. But before you speak, the Honorable Ken Okoth, I'm sure you have acquainted yourself with the provisions of Article 261, and particularly Sub-Article 9 thereof, which allows the next House the same latitude that this House had as far as enacting this particular provisions to gender parity are concerned. The Honorable Member for Butula.
Thank you, Mr. Speaker. I rise to support this bill. In fact, Mr. Speaker, I do support it in principle. It's true that there are certain areas that might need cleaning up and improvement, but I think the principle is right. Because, Mr. Speaker, the Kenyan people exercising their rights and their choices at the time of making the Constitution decided that elective and appointive positions should conform to the two-thirds gender rule. So I think it is upon us in this House and all the other Kenyans to ensure that that is fulfilled. Mr. Speaker, I think that was a way of providing in an affirmative way or affirmative action to ensure that that happens. The thing is, and why I'm supporting is the question I keep asking myself for this country, that we ensure that women participate in various activities as fully as possible. And I think it is good. And therefore, we should be looking for ways of implementing, and this is one of them. I think this bill gives us a way of ensuring that we achieve the 2/3 or 1/3 gender rule in this House. Mr. Speaker, I'm happy with the certain provisions in this, including the sunset clause that allows for 20 years. I think that is good, so that we are working towards a certain target. Personally, I have no problems with the extension of 10 years. Because reading what it says is that after that 20 years, if we have not achieved the 1/3 gender representation, Parliament may, because it does not say Parliament shall, Parliament may. And my taking of that or reading of that is that at that time, after the 20 years, depending on the prevailing circumstances, prevailing circumstances, the House then, in its wisdom, will decide whether there is the sense in extending or not. And I'm sure the circumstances there will guide the House accordingly. I have no problem with that. I'm also happy that there's provision that those who will benefit from this kind of nomination can only be nominated for up to two terms only. I think that is good, so that we don't just have people who may be here forever benefiting from this kind of provision on nomination. And I'm also encouraged that quite a number of the ladies who are nominated in this House, many of them have actually gone for election. They may not have succeeded, but even just that going out there and saying they'll make an attempt. Some have done well, some perhaps have not. But for me, that's encouraging. It's an encouraging step for those who have been here as nominated, trying to go in for elective positions. And Mr. Speaker, I would urge the House to support this. I want to thank the principals from both sides, because they have been supporting this rule, both from the majority and the minority side. They have been supporting this, and I want to urge them to continue supporting this position of 1/3 gender rule. Mr. Speaker, as part of the affirmative action, I know we have said at times some of the challenges would be the costs and the size of this House. But, Mr. Speaker, I think we just have to accept to pay certain prices. And I think in terms of affirmative action, we have done this in certain areas, maybe in different ways. We have done this in exams, where concern for girl child, I think, has made certain allowances be made in terms of the thresholds. We have done this even in certain areas of recruitment, some that are fairly strict, like in the forces. So I think we should be prepared to pay a price that will ensure that we give equal opportunity to both the male and the female populations. Because as it's been said, the population figures show that we're about 50-50. I think even the women may be slightly more. So in fact, there may be a slight majority. And if you look at the proportion, you wonder why those who are majority should be so underrepresented. So there are compelling reasons for us to go this way, Mr. Speaker. I listened to maybe the lawyer, like my friend Honorable Neto, and I did point out certain areas that might need to be cleaned up. I think it's important that that is done. We don't want to pass a law that would be difficult to implement or difficult to interpret. Mr. Speaker, as I complete, I really do support this, and even as we talk about elective posts, I know that the elective positions are more challenging, but I don't know why we have not achieved this in the appointive positions, which are less challenging, like, say, cabinet positions and other senior government positions and corporate appointments. I think the spirit and the principle should be absorbed and seen to be addressed in all sectors, Mr. Speaker. I think if we attain this, I believe this will also be a good mark of our maturity as a population, as a society. And in any case, quite a number of the women that have been invited, have been elected to this parliament, I think have been doing a fairly good job. And I'm sure even those who will be appointed will do a good job. Mr. Speaker, I do support the bill.
Honorable Vaya, to have a go at, or would you like to allow, because I can see the other members have just walked in, but it's being a matter that definitely we must have another day at. I think it's fair to allow you to have your say now, because you have been here with us for all this time. Proceed, the Honorable Vaya.
Thank you, Mr. Speaker. Mr. Speaker, I also beg to speak in support of this bill, Constitutional Amendment Bill, and I also want to join my colleagues who have spoken essentially in support of this bill. Mr. Speaker, this is one provision of the Constitution that the country has had a lot of challenges implementing, and we believe that these challenges have not yet been overcome, and possibly the way we have even at times have gone about implementing this has also created challenges. Mr. Speaker, the genesis of this is a constitutional provisions, which in itself no one would actually dispute or has controversy with, because the basic principle is actually contained in the Bill of Rights, Article 27, which is basically a principle, a fundamental principle of equality and freedom from discrimination. Mr. Speaker, this is a provision of the Bill of Rights, entitling and allowing that nobody should be discriminated on basis of gender, sex, creed, religion, and so on and so forth. And this is a principle found in nearly almost all societies that really have a claim to any democratic credentials. Mr. Speaker, the other constitutional principle that this bill seeks to implement is about the election system of the country. Some of the minimum standards set out, especially in Article 81.2, to the effect that not more than 2/3 of members of elective public bodies shall be of the same gender. Mr. Speaker, the threshold of 1/3 in a country where the gender the gender status is more or less equal cannot be said to be such a big threshold. And Mr. Speaker, it's actually a reflection of our cultural background that we have even a problem achieving this 1/3. But even more important, Mr. Speaker, some of the challenges informing why we have even been having challenges implementing this bill, of course, is that we have only attempted to enact legislation or possibly to just enact legislation. Yet if you really look at the Constitution implementation requirement, we were required not only just to amend the Constitution, but even come up with other mechanisms. Article 27, subsection 7 and 8, clearly make it imperative for the state, which of course include the legislature, to come up with legislative and other affirmative mechanisms to overcome past discrimination and bring parity on areas where there have been marginalization, which of course include the area of gender imbalance. Mr. Speaker, unfortunately, the political parties since 2010 have all focused only on enactment of legislation, and the efforts that have been made have also not been, I would really not say that they have not been fully embracing of these constitutional principles. Mr. Speaker, even when the court has actually been given an opportunity to interpret this, the principles have basically been relegated to aspirational principles. They have been described as essentially aspirational and not necessarily capable of immediate implementation. Mr. Speaker, even as we say that, it is clearly the case that until we have fully realized or implemented this minimum of one-third gender principle, the Constitution cannot be said to have been properly and faithfully implemented and to the letter and spirit of the Constitution, which require that at least in elective bodies, at least one-third of each of the houses should not, or each of the elective body should not, either gender should not exceed 2/3. Mr. Speaker, when it comes to implementation of this clause, Article 261, I even see that there are even challenges in regard to implementation, because Article 261, particularly 7, with regard to implementation, requires the President to dissolve Parliament in event of non-compliant. Yet, Mr. Speaker, under the current Constitution, the provision to dissolve Parliament was exclusively a preserve of the previous Constitution, whose provision that we are actually that had been saved, were only saved up to the first general election. So it turns out, Mr. Speaker, that as we speak, the President does not have any power under this Constitution to dissolve Parliament. So even if the Chief Justice was to actually notify the President would be, the Chief Justice and process of implementation would be acting in vain, because under what constitutional provision would the President be purporting to dissolve Parliament when the Constitution that was in force before 2010 has already been repealed? So these are some of the challenges we are experiencing. But we do hope that the members of this Parliament, or even of the 12th Parliament, will rise to the occasion and appreciate that, notwithstanding challenges of mechanism of implementation, there will always be a gap between what the Constitution says should be the case and what we are going to have. And it will, in the course of time, put the judiciary under clear scrutiny if it does not take the relevant mechanism to compel either of the houses to ensure that this Constitution is properly and fully implemented. Even then, Mr. Speaker, the national government can also make the work of members of Parliament, members of implementing the Constitution, can be made even much easier. Political parties themselves do also have a very big role, because they can also help a lot in terms of enhancing mechanism to implement the Constitution. So, Mr. Speaker, even as we debate this bill, I'm very sure, going by the peculiar circumstances of time and where we are, this bill may not see the light of day before the end of this Parliament. And it is therefore incumbent upon the National Assembly, the current one and the future one, to appreciate that the burden and responsibility for it to actually realize these very clear constitutional principles are really implemented. I know, being a male-dominated National Assembly, it is some of us feel that we are making possibly substantial concession to allow the fair gender to also get proper and fair representation. But it behoves all of us to appreciate that the reason why we talk about this principle is not about supporting the fair agenda. It is about mainstreaming gender affairs in our country. In a society where we want decisions to be made in a most objective manner, it is imperative that the decision-making process is not substantially handicapped by discriminative exclusion of members of one gender. It is the main victims are not just women, it is even men, it is the children and the rest of the society. So the constitutional principle is not meant necessarily to help women, it is meant to help society at large, and therefore this constitutional principle will not be avoided, it will not be eliminated. It's already entrenched in the Bill of Rights, it's already entrenched in the sections on legislative processes, and until we have possibly a referendum to remove those, we may not be able to eliminate it. But even more, I would really wish that we don't get there, a point where we want to say that we are abandoning some of these very clearly fundamental human rights about non-discrimination, merely because we believe that we think that we should not enforce this constitutional principle. Mr. Speaker, in the course of time, we believe if the state employs mechanism both long-term and short-term, it may not possibly even be necessary within 20 years to review the period of implementation, because most probably the country will have listened to the occasion and given fair treatment to all genders in the country, rendering it unnecessary to extend the scope of implementation of this bill. With those few remarks, Mr. Speaker, I beg to support this bill.
Very well. We'll now give this opportunity to the Honorable Member for Vihiga, the Honorable Yusuf Chanson.
Thank you, Mr. Speaker, for the opportunity to support this bill. Mr. Speaker, this matter has been brought to us in this House on several occasions, and I think now the approach that has been taken would have been ideal, only like my colleagues have said about timing. But in principle, I support the idea because this is what came out during the views, when Kenyans were giving views on how the kind of new constitution that Kenyans desired. So I think it is important that Kenyans are given what they desired to be in the new constitution. Mr. Speaker, the 20 years, I think it is good because then it gives time. It is like there was lack of preparedness the time when the constitution was being implemented. And I think that is enough time so that there is adequate preparedness. Although the level of education and so on, education and the job opportunities, particularly starting from education, there are equal opportunities now for girls and boys in this country. It's only some kind of problems we have with some cultural behaviors and beliefs which have hampered the development of the gender issues in various places, parts of the country. But I'm sure if there is enough time given so that there is awareness all over the place, it will be easier to implement than having to get people into positions where they are not prepared. So either way, it is very important, the period that has been given. And this is very important because it is creating opportunities for all in the country. We have, on several occasions also, come to the realization that in some of the places, like in schools, you find in some of the schools, the boy child is also being affected by too much talk about the girls. But I think when there is enough time, and I hope again, when we talk about the fact that the enactment of this bill shall occasion additional expenditure of public funds, I'm sure there is going to be more awareness created all over the country to ensure that everybody is at peace or at ease with it. The Rwanda situation, I keep on quoting the Rwanda situation where there was genocide. And I think when President Kagame decided to have more women in government, I think there has been peace. And there has been a lot of progress. Because I think women tend to be more peaceful than men. And even in carrying out certain assignments, I think it is easier to carry it out through women. Even you find, Mr. Speaker, in our place where we come from, the churches are for all. But you find that most of the time you go to churches or religious places, the people you find mostly are women. And that's why there has been a lot of peace in those churches, and until maybe when they get infiltrated with some men who are out to divide the church. So this is taking into account the issues that were not foreseen during the time of making the Constitution, and it is also because there are a number of issues because of the time that was taken and the kind of pulling aside that there was, the competition there was when the Constitution was being drafted and being written. I remember the time when the Constitution was being passed in Parliament, we could not debate it. We said that members of Parliament passed the Constitution the way it was, but I think we just passed it the way it was because there was so many vested interests pulling in different directions. So now that the minds have settled, I think it is the right time for this to be brought up. There were the contentious issues, which were among them this one, which I think now is good time for it to be debated when members or when Kenyans are sober in their thinking. So the most important thing is that we should be able to take care of the proportions, as has been said, like where we, like in the law that we have, Article 90, which says, except in the case of county assembly seats, each party list reflects the regional and ethnic diversity of the people of Kenya. These are very important ones, but we have not been able to adhere to it even on the position that we have been able to give out, leave alone the issue of women. Just the issue of, even when we have appointed in government, we have appointed cabinet secretaries, we have appointed principal secretaries. This has not been adhered to adequately. And I hope now and this is what is causing, sometimes when we see a lot of division and a lot of animosity when we are having campaigns. These are some of the issues that are bringing up this. When you see a lot of hostilities, people those who are campaigning for positions, even for presidential level, not having one idea about what the country should be like. Campaigning in different directions because some of these aspects which were in the Constitution have not been adhered to. Mr. Speaker, it is important that the issue of, as we talk about the gender rule, we must also think about the regional and ethnic diversity because Kenyans, all of them, in fact, Kenya thrives on taxation. Apart from income tax, which we pay ourselves, those who are salaried, the rest of the people, they pay a lot in terms of VAT. That's 16%. It's a lot. It's a big proportion of the revenue that the government collects. So because of that, I think each part of the country deserves to be served the way that the way it is contemplated and the way it is expected by the Kenyans who live in everywhere in the country. And once this is done, I'm sure it will be easier for everybody to be taken on board. It will be easier for people, every Kenyan, to feel that sense of belonging. And I think that's why it is important that such a bill is debated and everybody is made aware of what is happening. With those few remarks, Mr. Speaker, I thank you. And I support.
Thank you, Mr. Speaker. I rise to support this constitutional amendment bill as proposed under Article 90, 97, and 98. As I do so, Mr. Speaker, I am one person that believes that for this nation to develop and to make sure that there is full participation of all Kenyans, we must make sure that we include gender in terms of our consideration in every sector of our economy. I know when we are discussing this 2/3 or 1/3 gender, we normally like referring this matter as a women issue. Mr. Speaker, this morning I had an opportunity to visit a school in my constituency, Limu, in Kameredo, and at the same time I had a chance to meet NYS Kazi kwa Vijana program, and I looked at the numbers of the students or pupils who are in this school, and Mr. Speaker, I was surprised. Majority of some of the kids that are in school are female. I also saw that many of the Kazi kwa Vijana participants are also female. They are more than men. Mr. Speaker, I would like us to know that at the time will come that we, the men who have been reluctant to push this bill, will be marginalized at one time. Last week, for those who are in the Madaraka Express, may remember how many ladies were in that train providing various services. And I saw the ratio of men to the ladies was like 1 to about 8. Mr. Speaker, I think it is important for us to know that we can no longer hold the wishes of this country. This was the wish of the people of Kenya, that no gender should be more than the other, that we must open doors for those people who feel that they are not having a fair opportunity, and at this time in our development of this nation, the women, particularly in elective positions, they have a hard time to have a fair competition with the men. And the men seated here are also married. They are people with their daughters. In my household, we are only 2 men against 4 ladies. And when I consider their potential, the women in my house, I would never want them to be constrained to do what they must do for this nation just because they belong to a certain gender. And for this reason, Mr. Speaker, this country, Kenya, should not even benchmark ourselves to our neighbors. I looked at the countries which say are first world. They are struggling with the same kind of thing, even European or American. But Kenya can show the way forward by allowing this gender route to go on, to make sure that we allow all the genders to take a meaningful role in development. I think if we allowed our women particularly to get into areas of employment, areas of leadership in this country, we will unlock so much energy that we can take this country to another level. Mr. Speaker, if we keep on holding this, and for various reasons that we may have, Mr. Speaker, we are holding this country back. So it is my wish that we should not leave this matter hanging for forever. It should be finalized, and I pray that we men particularly must also remember tables can be turned around, and we could be crying in the future that we wish this bill was passed to safeguard the main interest. So, Mr. Speaker, I think it is important that as we go forward, that all of us, look at the right mechanism and propose the right ways actually to ensure that this gender rule is successful in this country. I support. Thank you.
Very well. We shall have the Honorable Amunyenye.
Thank you very much, Mr. Speaker, for giving me the chance to also make a contribution on this bill that is before the House. Mr. Speaker, let me state at the outset that I am not opposed entirely to the issue of ensuring there is a gender balance as envisaged in the Constitution. But, Mr. Speaker, I respect and I always believe in the independence of this House, Mr. Speaker. Mr. Speaker, this bill was brought before the House because the President directed you to bring it before the House. He directed the Leader of Majority to bring it before the House. That means if he had not, this bill would not be before the House. And I'm also sure, Mr. Speaker, that even at the time the President was giving that direction, he knows or he knew that this was going to be an exercise in futility because it won't go through, Mr. Speaker. Mr. Speaker, campaigns are going on. You cannot use this law, Mr. Speaker, to be supporting the women agenda. This is a campaign gimmick that should not have been allowed, Mr. Speaker. Mr. Speaker, I am sure we have just 1 week to go. This House is just going to be sitting for the next 1 week only. On the 15th, we are adjourning Sinedai. And for you to implement this law, you'll have to go through another very important stage. This law will have to go through this second reading and go through another third reading. Mr. Speaker, ordinarily, although I know that this is a matter which has been on the table for quite a while, but I have not seen the latest committee report, a report that would be giving details which also include the comments by the public. So this is something that, as a country, Mr. Speaker, we need to point out as a parliament.
The Honorable Wamunyenye, I want to give you time. I know you are very passionate about this matter.
Yes, sir.
So just take your time and express your points clearly.
Thank you, Mr. Speaker. Thank you, Mr. Speaker. So the point I'm trying to put across, Mr. Speaker, is I ordinarily expect that for this kind of bill to be brought before the House, there ought to be a report from the relevant committee of Parliament. But in this particular one, there is no such a thing because the President in a baraza just directed that this bill must be taken to Parliament. And it is time that these institutions are respected, Mr. Speaker. The institutions in our country, the legislature, must be independent and transact the business independently. And that is why you are there. You are the chair, Mr. Speaker. So we do not have to entertain campaign gimmicks, where in fact it is obvious that you're not going to raise numbers to amend the Constitution in the next 1 week, Mr. Speaker. This is why I tell you it is futile, for you to get this before the House, or maybe it's a PR exercise, but this won't help the President, Mr. Speaker, because the people of Kenya, the 10 million strong, have already made up their mind. The 10 million strong NASA supporters have made up their mind. This won't help, Mr. Speaker. So, as much as I know it is important, we have wives, we have children, girls, and ladies that are also entitled. But in the spirit also of equality that we keep talking about, Mr. Speaker, the ladies, they feel they are also equal to men. And I believe in the eyes of God also. All persons are equal, Mr. Speaker, in the eyes of God, unless you know anywhere that God has given different ratings to his people. We are all equal in the eyes of God. So, Mr. Speaker, let this be a natural aspect. God has given us, the power to rule over the world, and we should do it, all of us equally. Why are women contesting for seats? Why don't they just wait for an allocation? Because they are competing men. They're also competing other women. Those special seats in the counties for women are enough, Mr. Speaker. And I really feel, Mr. Honorable Kiragu, my friend, my good friend Kiragu, I feel the same. I empathize with your thought. But this is not something you want to sit and say, people are seated there and they should be given free seats. Why give those free seats? Let them fight for them. They should be able to fight for the seats, Mr. Speaker. We have been talking about the cost. And every day, even in government, people have talked about the cost of running, the cost of salaries, the cost of running institutions such as ours. Mr. Speaker, you are aware there's a lady called Sarah Serem. She inadvertently just cut our salaries. She reduced our salaries and allowances and went away with it, Mr. Speaker. The reason that was advanced when she was doing this is that members are too many and you're eating too much, in the resources which would otherwise go to development. Now, if you want, Mr. Speaker, after elections, to allocate new seats proportionately to political parties, to nominate in order to get a balance of some sort, is it going to cut down the cost or is it going to increase the cost? These are the facts that must be considered, Mr. Speaker. And I am very sure that if that is going to happen, this House already has 359 members. 359 members, Mr. Speaker. That number is big. We would be talking about mechanisms of getting rid of some constituencies which ought to be wards. Mr. Speaker, some constituencies have just about 60,000 people, while others are 400,000 people, like my constituency. It's over 300, close to 400,000 population of that, with over 110 voters registered. So, Mr. Speaker, in my view, the thing that we would be dealing with now will be how best to go about the process of reducing numbers of, of members of parliament, reducing numbers of constituencies, reducing the costs, because you increase the number of members here, you must also increase the staff. It's going to be costly, to maintain an MP. It's going to be costly to maintain a member of staff here in parliament. So you would just be doing more harm to Kenyans who are already overburdened. Because this is going to be taxation, you will also increase taxation when money is required to service to deal with the issues, of meeting the costs of operation of parliament, meeting the costs of operation of the commission, meeting costs of even running constituencies, Mr. Speaker.
And the Honorable Munyenye, yes, I like your line of argument. And also considering that those who are already even here and debating this very important matter that touches on the gender parity issue, the ones who are already here don't seem to be even interested to debate.
Mr. Speaker, that is the point. Are we trying to create opportunities for people to come here and make money and not make any contribution? Or what is it, Mr. Speaker? I have had the opportunity, Mr. Speaker, to visit some of the most developed democracies. I've been to the Congress, Mr. Speaker. I've been to the House of Commons. And when you get to those developed democracies and you talk about the gender, they ask you, what do you mean, Mr. Speaker? They don't know this thing called gender. That gender balance. And go to those institutions, you'll find that there is nothing like that. Why double standards? Why impose it on countries that are developing? Leave it to us. Let us manage our affairs, Mr. Speaker. Because our ladies in our country, and the community I come from in particular, Mr. Speaker, which you also happen to come from, you know the role that the ladies play at home. You know what they are expected, and they do it very well, given a chance, Mr. Speaker. They do help the families. When the ladies get something, the family has got something at home. And we also get to build families, to build the nation through them, Mr. Speaker. Most of those who are here, you hardly see them building the nation, Mr. Speaker. You hardly see them even making children. They don't build the nation. So, Mr. Speaker, I do not think that it is right for anybody in Europe to lecture Kenyans. The non-governmental organizations, some of the NGOs and civil society have been pursuing this. But when you look at those countries funding these activities, like those I mentioned, Mr. Speaker, they have nothing called gender in their countries. They have nothing called gender balance in their countries. But when they come here, they send a few people in Kenya with some money to come and lecture, people in Kenya, civil society, and to tell Parliament what to do. And the President also follows and directs Parliament to sit and pass the law. We must get away from this, Mr. Speaker. This is legislature. This is a National Assembly. And you need to consider your own business. The Constitution gives you power. Don't take directive from anywhere, from the President. Let him run executive. Let him run government. And let Parliament do its business. Nobody from anywhere should come to lecture Kenyans about this, Mr. Speaker. Let women fight for seats. Let them be elected like men
In any case, like I said, we are equal, Mr. Speaker. So we shouldn't have to go that direction of having, to follow being directed on what to do. But, Mr. Speaker, having said that, Mr. Speaker, I wish to condemn some of the commissions. Some commissions have been done by some members of government. It is not fair by government not acting to protect women, Mr. Speaker, in some instances, where they have been raped, where they have been mistreated by some men, some crooked men, Mr. Speaker. You can talk to a woman. You can talk to them, express yourself. Why do they use force on women, Mr. Speaker? And some of the cases you hear are staying in court for 6, 7, 8 years, Mr. Speaker. This government pretends. Some cases criminals have been acquitted for mishandling these cases, Mr. Speaker. Recently in my constituency, on Friday last week, a policeman shot dead a woman who was selling machungwa. This small trader who was selling machungwa and mboga. And this policeman just removed the gun and shot her dead, Mr. Speaker. Police are expected to protect. And this is why they are utumishi kwa wote. And they should not take sides. They should not be supporting Jubilee. Because Jubilee has just a few days to govern this country. NASA will be taking over, and those policemen will be under NASA. They will be serving Kenyans and the new government of NASA, Mr. Speaker. Let them be reminded that they are utumishi kwa wote, serving all Kenyans, Mr. Speaker. And when an innocent life, like I saw on Friday, lost from a bullet to an innocent woman struggling, selling hamburger to make a living, to meet obligations for her family, then she loses life like that. Mr. Speaker, and as we speak now, I have not seen action taken. I have not seen action taken. We want to see justice done, that this officer who shot Mama Kadogo should be arrested and taken to court, Mr. Speaker. Some others, a bicycle rider, was also shot from my village, Mr. Speaker. Wekesewe Chaluka came from my village, Mr. Speaker. You know Boema, at the hill, the place, the Durian place for Nigerians, Mr. Speaker. He comes from there. He was shot, and a bullet lodged in his leg. One of the bones, the tibia, was shattered, Mr. Speaker. So it's going to be very costly even to get him treated, so that this is someone who rides a bicycle to earn a living. Now the leg is shattered. Is he going to do this again? Is he going to get something for his family, for his wife and children? Obviously, no, Mr. Speaker. And someone somewhere is trigger happy, enjoying. Should there be fresh training to some of them? Or what should it be? What is most annoying is that the police were moving with Jubilee youths who were armed. Those Jubilee youths were armed with crude weapons and descended on innocent people. I'm expecting the Electoral Commission to act on this, because this amounts to electoral offenses, that they have meted violence on innocent people. And that's why, Mr. Speaker, I tell you that this government of Jubilee must go home on August 8 to save Kenyans, Mr. Speaker. The price of unga, the price of sugar, the price of milk, corruption in high offices, Mr. Speaker. Where are you heading, Kenya? Where is this country heading? Mr. Speaker, for this Kenyan to survive, for Kenya to survive, and for Kenyans to lead a fairer life, Jubilee must go home. Mr. Speaker.
The Honorable Amunyenye.
Mr. Speaker. Mr. Speaker, if we all as Kenyans feel what the ordinary Mwananchi is feeling, we must work towards ensuring that this government goes home, Mr. Speaker. And Mr. Speaker, I hope that everybody, even those, some of the Jubilee supporters, Mr. Speaker, should be getting this message so that we get Jubilee going home and saving Kenyans, Mr. Speaker. With those few remarks, Mr. Speaker, I wish to state that I am going to withhold my support for this bill.
Very well. Honorable members. The time being 6:30 p.m., this House stands adjourned until Wednesday, the 7th June 2017 at 9:30 a.m.